We're going to start in just a few minutes, everyone. We're giving folks a chance to log in. Okay, looks like we have a little cluster of folks joining us. Maybe one more moment to give everyone a chance to get in. Okay, let's get started. Good morning, everyone. Before we officially begin, I have just a few housekeeping details. First, I wanted to alert you that live closed captioning is available for this conference, and you should see that on your screen. Also, we've been approved for 5 hours of general CLE credit. Jordan Burgess will post a link to the CLE attendance form at lunchtime, and you will need to complete it after the seminar is over and email it to Leanne Ross at lross1@udayton.edu. And if you have questions throughout the day, please use the Q&A function to post them. Okay, now it's my pleasure to move into kind of the official portion of the day. I want to welcome you to the University of Dayton School of Law's annual conference on education law. I'm Associate Dean Lori Shaw-Roble, and I'm acting today on behalf of our Dean Andrew Strauss, and I could not be more excited about today's conference. This year's focus is on the law of special education, and we couldn't imagine a better place to begin our discussion than with the seminal case of Rowley versus Board of Education. In my job as Associate Dean, I work almost every day with students who have disabilities in one form or another, and I have been amazed over the years that I have been working about the incredible changes that have been made and how much better things are. I think we still have a long way to go, but things are so much better than they were 30 years ago. We have an incredible group of presenters today, starting with Dr. Amy June Rowley, the plaintiff in Rowley versus Board of Education, who will share her unique perspective. And as the day progresses, we're going to learn about disability law in higher education. We're going to explore the current status of special education law. We're going to consider the special role of lawyers working with special educators, and we're going to get a glimpse into how nations around the world provide special education. I'd like to give special thanks today to Professor Charlie Russo, who, as always, has worked tirelessly to put together an amazing program and an amazing panel. Now I'm honored to welcome our keynote speaker, Dr. Amy June Rowley. Dr. Rowley was the subject of Board of Education versus Rowley, which you can find at 458 U.S. 176. It was a landmark 1982 decision that interpreted the Individuals with Disabilities in Education Act, IDEA, for the first time. Amy's parents sued her school district when Amy was in elementary school for failing to provide her with a free, appropriate public education as required by the IDEA. And her presentation today will focus on a review of what happened from her own perspective, as well as a look at the journey of this decision over the last 40 years. Dr. Rowley currently serves as the coordinator of the American Sign Language program in Modern Languages and Literatures Department at Cal State East Bay. She completed her dissertation in second language education and urban education from the University of Wisconsin-Milwaukee, which focused on American Sign Language Advanced Studies programs, implementation procedures, and identifying empowering practices. She holds a master's level certification in American Sign Language Teachers Association, ASALTA, and is currently the director of the Evaluation and Certification Program for ASALTA, or ASLTA. Her research interests are systemic and hierarchical structure of American Sign Language programs in post-secondary institutions and relationships between students and interpreters and the deaf community. She's published articles relating to autism, oppression, and special education experiences. Prior to coming to Cal State East Bay, she was the coordinator of the American Sign Language program at the University of Wisconsin-Milwaukee for 9 years. Dr. Rowley, please allow me to welcome you to the University of Dayton School of Law, even if it's just virtually today. There honestly could be no better way to kick off our discussion of what the right to an appropriate education has encompassed and should encompass than to have you share your story. So again, thank you for coming. And Dr. Charlie Russo is going to be moderating this panel.
Thank you so much for inviting me today. All right, well, let's dive in. First of all, hello, everyone. It's nice to sort of see you, even though I can't actually see you through Zoom. It's my pleasure to be with you this morning to share about my educational experience, particularly with this audience, all of you being very interested in the law. I often see, I think you don't often see the individual story behind what has happened. You just sort of see the black and white results, but I'm happy to share my experience with you today. Let me start with a little bit about myself. I was born in New York in 1972. That's right, I'm 50 years old. My parents are both deaf. And my parents are Cliff and Nancy Rowley. My father grew up in California and moved to New York. His father served in the war and upon returning decided to sort of start a new life there. My mother is from Rochester, New York in upstate. They met in college and got married after that. My mother's job was to teach deaf children. My father worked as a chemist. They both worked after they got married until my brother was born, at which time my mother left work. My brother is hearing. Now, both of my parents come from hearing families, meaning their parents are hearing, so it was not a surprise that their child was born hearing. Both of my parents became ill at some time in life and lost their hearing. My father at 6 months, my mother at the age of 5, and my mother lost her hearing more slowly. from between the ages of 5 and 13. She became deaf at 13. And my mother didn't learn to sign as a child. She actually didn't learn to sign until college, which is where she had full communication access for the first time, which was huge for her. My dad did have access, not in the classroom. In the classroom, he was relegated to oral communication, but in the dorm or with friends, he was able to use sign language clandestinely. Over the years, the school became more lax about the prohibiting the use of sign language because all the students signed. And it's very hard to prevent students from communicating in a manner that's the most accessible for them. Deaf people have always had struggles with complete access to communication. And that's an experience that was also true for my own parents. My father attended Fanwood School, which is the New York School for the Deaf, starting at the age of 5 or 6. And they had a rather unique program at that school. This was not uncommon to deaf schools in general, but this was considered somewhat of an experiment at the time. These children were not allowed to sign at all. They hoped to separate them from what they considered to be tainted students who used sign language, students who had already absorbed some sign language. So this idea was to keep them purely oral. So my father and a cohort of other children were separated from the general population. They slept and ate and attended all of their classes separately from other deaf students. So they were an experimental group of students. I'm not sure how long that experiment lasted. And it was considered a failure because there were a couple of kids in the program that came from deaf parents, from deaf families. Those parents told the school that they never signed with their children, but the parents signed with one another. So the children naturally picked up on that. So this experimental group of other children who were not theoretically exposed to sign learned it from these children that came from deaf households. So these poor parents got blamed for that, rather than knowing that that's a natural tendency of the deaf brain to seek out visual language. So again, my brother was born hearing. 2 years later, I was born. And again, my parents had no expectation that I would be deaf. They didn't have any suspicion that I were deaf, that I was going to be deaf, because they both came from entirely hearing families. There was no expectation whatsoever that they would have deaf children. So they raised me more or less as a hearing child. About at the age of 18 months, my mother began to observe that I was quite different than my brother. I feel she already had a sneaking suspicion, but at the age of 18 months, she perceived a red flag. There should be clear communication. By that age, my brother was able to speak and use his voice at that age, whereas I did not or would not. I signed exclusively, and I observed my parents in a very highly visual way that she recognized as a very deaf approach. She did not sign with me. Again, she had grown up hearing, so she had full access to speech in terms of expressively. And she would sit across from me and use her voice. And she shortly realized that that's not what I needed. That was not effective communication for me. So I was quickly sent for a hearing test. I think the process at the time was quite a bit more complicated than it is now. I'm not totally sure exactly what happened, but it took a number of months for them to arrange those tests. And at that time, what they did was expose me to as much sign language as possible. As soon as they realized I was deaf, they felt that they had months of catching up to do with language access for me. So I was exposed to as much signing as possible. I think they were sort of feeling guilty and doing their best to catch me up on anything that I missed in those 18 months without communication. And in their perspective, I was on track by the time they learned I was deaf, or that it was confirmed by the medical establishment. So I continued to grow up in that family with communication access from my parents. I played with my brother and so on and so on. As the time for me to enter kindergarten approached, I was going to some sort of couple of times a week daycare situation. I remember playing with other kids, riding bikes, things like that. I remember the teachers being there, but I don't think there was much formal instruction. I remember it being very independent and not requiring a lot of group activities or things of that nature. So at the age of 4, when there was a year left for me in that situation, a new law came on the scene. And my mother was paying quite a bit of attention to that and knew that I could potentially be mainstreamed. That was really not an option prior to that time. The school for the deaf was a bit of a drive away, 30 or 40 minutes from our home. And it was a school at which my mother had worked and seen firsthand how many children came to the school experiencing severe language deprivation and delays. So putting me in a classroom with those students seemed to her like it would not give me many opportunities for success. She didn't think it was the right environment or the right placement for me. My brother attended a school that my parents had a great relationship with, they felt very comfortable with his setting. So they wondered if it might be possible to make a choice such as that for me versus the school for the deaf for them. So this law was called PL 14942 at the time. Handicapped Children Education Act before it was later called IDEA. So this law was enacted, and at the time, my parents asked the school if they would provide an interpreter for me. They talked with the school and with the principal and explored the possibilities of me attending the school and then potentially providing interpreting services for me. And the school seemed quite receptive at the time. My parents were quite thrilled to hear that. So that conversation happened before I even attended the school. They asked if the school needed help in locating a qualified interpreter, and were told that they did not need that help. So again, some number of months passed by, and routinely my mother would inquire if everything was set and ready for me before I would enter kindergarten. And again, right before the school year began, my mother asked the school if they were ready for me, if they had an interpreter, if everything was set, and if they needed any help. And the school said, everything is good, we don't need your help mentality. So everything seemed like it was going to be satisfactory. My parents trusted that it would be. And I do remember my first day of school. I'm not sure if everyone does, but that's something I do remember from being a 5-year-old. I remember entering the classroom with my backpack. My mom sent me off to the classroom, got out of the car and gave me a hug, and whatever she said, something like "have a good day," and explained what I should expect. So I walked into the classroom following the line of students and put my backpack on its hook and my jacket and so on, and found my seat. And there were a number of adults sitting to the side of the classroom, I recall. School ended about noon or something, and my mom came to get me and asked, how did it go? Did you have an interpreter? And I said, no, there was no one there that signed with me. which was, of course, a surprise to my mother because she had been reassured repeatedly that all was ready. So she reached back out to the school that had a TTY, which is the old-fashioned communication device for deaf people, a teletypewriter called a TTY. So it was this huge green machine, almost like an old telegraph machine, or it was an old telegraph machine that had been converted for deaf people. So my parents had one at home, and they had one at the school as well. So you would pick it up, there'd be these little beeps, you'd put the regular hearing phone handset down onto the TTY, call the school, they'd hear the beeps, and then put their handset on the TTY. And the school had experience in communicating with my mother this way, since my brother was also a student there. So the school district office, however, or my mother said to them, the school district office had not gotten an interpreter and was wondering, what was going on. And she wasn't able to get a straight answer from them. And as time progressed, I continued to be attending school without an interpreter. And of course, my parents were quite upset by this. They eventually started a mediation process with the school. And meanwhile, I was quite far into the school year, the kindergarten school year. The mediation between my parents and the school didn't really seem to be going anywhere. And finally, it was agreed that there would be an interpreter for me on a temporary basis of 1 month, or trial basis of 1 month. And they felt that I didn't, in fact, need an interpreter, but that they would try out having an interpreter. So again, my mom warned me what to expect. So again, I went to school with my little backpack. But when I went to hang my backpack on the appropriate hook, the bench that was in front of the hooks was full of adults, full of people, maybe 10 or 15 people. So all of us students couldn't hang our backpacks as we normally did. I think these people were the principal, perhaps the school district's lawyer, an audiologist, a speech therapist, so on and so on. I don't actually know for sure, but it seems likely that that's who were these people. And then an interpreter entered the classroom. And I have to tell you, I freaked out a little bit. Because for me at the time, I had never seen an interpreter. I didn't know what an interpreter was. I didn't know how it worked, what they were for, what they did. It was not something that I was familiar with. Access to interpreters was not something that was easily gotten at the time. Plus, I was 5. I was a small girl as well. All of the children were quite small. And this interpreter was really large. Maybe they weren't in general, but in my perception as a small child, he was this very tall man wearing all black. And wearing all black or otherwise contrasting clothes is very common for interpreters. That's an appropriate practice. But for me as a kindergartner, I had never seen a person in all black in my whole life. So I think there was no warm or inviting feeling from this person. All of us students were a little intimidated by this tall person in all black. And then to make matters worse, he followed me around the classroom. So every time I was doing something, here's this tall black figure that I just cannot emphasize enough to you how large and looming he felt, that was interfering with what I was doing. And I was genuinely frightened. So my first impression was one of near panic. This man in all black following me around my classroom. I sort of became glued to my teacher, and the teacher was trying to soothe me and had the interpreter sit, and it, that helped, but it was still very off-putting. My mom had wanted to be there that day But when they learned that so many unexpected adults would be in the room, they decided it would be overwhelming to add to that. And she also just didn't want to add more stress to that environment. So I was crying and confused, and they were trying to visualize how they could improve that situation for me when I got home later. So I think that interpreter attended class with me for about a week, and then again, all of a sudden, he just disappeared. And my parents were very upset to discover that he had just disappeared. They felt that the agreement had been to have interpreting services for a month, and was only a week, and that it was unfair to remove the interpreter so quickly with no discussion. Many years later, I read the interpreter's report about working with me, and he reported that although I had attention abilities and language abilities, I was afraid of him and that I didn't need interpreting services. So that language that the interpreter used really followed me for a long time. And I remember clearly being very frightened of this large figure in black looming over me in the classroom. And, none of us children understood what was happening. No, and none of the adults recognized that I was frightened by this large looming figure following me around my classroom, that I had never seen an interpreter before or anything like that. The formal training programs for interpreters weren't quite developed like they are now. So he was trying his best to be professional, but it was actually not linguistically or um, otherwise appropriate the way that he was conducting himself in the classroom, meaning he was not being warm and friendly with me in any kind of way. So by the interpreter being removed at that point, I just, sort of moved on with schooling. My parents decided to sue. The process was still going on as I entered first grade. So for first and second grade, I had no interpreting services. I had a week of them in kindergarten, but none for the rest of the year. And then it was third grade in which I started to really struggle. Kindergarten and first grade, you kind of play around. It's a little bit more unstructured, but interpreter correction. By second grade, you really do have to sit in your desk. You have to attend to lessons. And my mother, again, was a teacher. She really enjoyed teaching. So what happened for me was every day after school, my mother would teach me everything that I should have learned. So my teacher at school was not actually my teacher in any sort of way. The teacher should not get any credit for my education. My mother was my teacher. So as the lawsuit progressed, my parents won. The court sided with my parents. They said that the need for an interpreter was obvious. However, the school district appealed. During the appeal process, I continued to have no interpreting services in my schooling. So this was something I just had to deal with. The case made it to the Court of Appeals. My parents won that case as well. The judge's decision was a stay, saying that Amy must have interpreters. You cannot delay this by appealing. You need to provide interpreting services, and you need to do so immediately. So for third grade, I finally had interpreting, and I cannot express to you the difference in my experience. I had some enjoyment in first and second grade, but my third grade, experience was rich and full of language and access. It's as you could compare it to the difference between an envelope with 1 or 2 pieces of paper in it and an envelope that's literally stuffed to the brim. My 3rd grade experience would be that rich and linguistically fulfilling one. My classmates were often pulled out for other things, as I was as well, so I didn't mind too much being pulled out for speech, for other things. And the speech teacher was very positive and thoughtful. And I noticed other students were graduating from speech, and I assumed I would as well at some point. And I was actually excited to complete my speech therapy with the instructor, but I was told that I, unlike all of my classmates, would never be able to stop speech training, that I would never graduate. I would forever be in speech therapy. And I was really taken aback. I remember being very sad about this. I mean, really kind of heartbroken. And I asked my mother why I wouldn't be able to graduate speech therapy like all the rest of my classmates. And honestly, at that point, I no longer enjoyed speech therapy anymore. I felt like there was no value in it. I think it's really wonderful how at such a young age, I was able to recognize how displeased I was with what was happening to me. And it actually was trauma. And it was this one small, perhaps, thing, but it really had a huge impact on me, and how I'm certain that the speech therapist did not anticipate what an impact her words would have. So as I said, I had an interpreter in 3rd grade, and that interpreter had deaf parents. You may be familiar with the movie CODA. It stands for, it's an abbreviation, Child of Deaf Adults. When I was in 3rd grade, no one had heard the phrase CODA, but it's more common now because of the film. So again, this interpreter had grown up with ASL as her first language. She was a very fluent signer. And the school hired her to work with me as my interpreter. I remember she interpreted for the teacher and the students, and she really encouraged the students to interact with me, to not depend on her for all of that, but she helped them figure out communication techniques to include me. Out on recess, she would interpret what was happening at recess. I had always played independently in any kind of break. I had a very active imagination. I never participated in the group activities, but she encouraged me to do so, taught me the rules or interpreted the rules to me, and I was able to participate in teams and other group activities throughout the year as a 3rd grader. So 3rd grade was an absolutely amazing year for me. I loved the teacher that I had. She loved working with the interpreter, and everything about school seemed great. The school was friendly to my parents. It was always the school district that was the sticking point. Seemed like they and the lawyer had something to prove, that they wanted on principle not to acquiesce to providing an interpreter. I often got the feeling that the school was rather stuck in the middle between the school district and my family. So 3rd grade was an amazing year. 4th grade, however, the school knew that the Supreme Court had agreed to hear their case. So they went to great lengths to ensure that we would lose So I was not given access to that same interpreter from third grade again. They brought in someone who was not an interpreter, but she was a special ed teacher working with deaf and hard of hearing students. And of course, my parents protested and insisted that an interpreter was needed, that I needed to learn like the other students, meaning from the teacher, just through a language specialist known as an interpreter, not through a secondary teacher. The school insisted, or rather the school district insisted, that I would benefit from working with this additional teacher. An interpreter wouldn't be able to pull me out of class and work with me in a one-on-one manner in that way. So the school district insisted that this additional teacher was actually a better fit. And my parents were pretty fed up at this point. They were arguing so much at this time about over my IQ. My parents knew that I was very bright, and having access to the interpreter proved my ability to do well in classes. Barely passing a class was not considered acceptable in my family. My mother was a teacher, as I've mentioned, and my success at school really depended on my mother taking the reins of my education and teaching me. And she wanted to do that partly to ensure that I was seen as the bright child that I was. The school district, however, insisted that I was not very bright and that if anything, I was very average. So they agreed to allow me to have an IQ test. I was pulled out of school for it, given some rather extensive tests. They did it, however, in spoken language, in spoken English, which of course my parents protested once again. So then they found a school psychologist who was fluent in sign language, who was able to give me the test in sign language. Versus the school that I attended, the person who gave me the test just used their voice. So I'm trying to lip read this person, and the results were very different. So then it became a bit of a war between the two psychologists, and they felt that it was unethical for me to continue to be tested. But I did have to take the test a multiple number of times, and the results got better and better. And it wasn't that I was actually getting smarter, it was that I was becoming more and more familiar, of course, with the test. And finally, they decided that the test was invalid after all, because your IQ isn't supposed to change. So it was a very interesting experience to sort of be in the middle of this battle between school psychologists. The Supreme Court looked at what we could call a snapshot of my time in school. They looked at a year in which I had no access to interpreting services at school, where my parents taught me. They didn't look at the third grade year at all. They only evaluated the second grade year. And of course, this was not a complete picture of my educational experience. They didn't do a comparison between me attending school with an interpreter and without an interpreter. My experience of having the deaf and hard of hearing teacher functioning more or less as an interpreter was very different from having the professional CODA interpreter. Again, I was on my own at recess. Occasionally I might play with another child on the swings or something, but I was not included in group activities because of the lack of communication. So I returned to my very solitary experience. I remember very clearly doing a fun science experiment, and the teacher was pouring various liquids into a beaker, and then they kind of exploded. And I really wanted to know, I was so excited to do this. And the interpreter was sitting there watching without, or excuse me, the teacher, my teacher, was sitting there watching, but not telling me what was happening. And I kept asking her what it was. Of course, I wanted to know at the same time as everyone else, but instead of providing me with communication access, she would say things like, oh, please wait, I'm going to tell you later. I'll tell you in our classroom later. Don't worry, I'm watching for you. And it meant that I would sit in silence in the classroom for a great deal of time. And I have to say, it definitely affected my mood. My mom could tell that I was very unhappy. It's a really tough situation to be in. The school provided some access, but would I call that appropriate? I don't think so. That's where the definition of what appropriate really means comes into play. So the Supreme Court announced their results. I was never in attendance at any of the court cases. I do remember my parents talking about how stressful it was, and I could see how much stress it caused them. My mother wasn't working at that time. She was always home except when she went to court. So I would always know when she was at court. And they had a hard time finding babysitters for me because having a deaf child makes it hard to have somebody who can communicate with you. So my hearing grandparents would come and babysit for us. And they didn't sign. So they found it very frustrating to communicate with me. And I was really frustrated trying to communicate with them. I wasn't a tough child, but one needs communication. And I got blamed for their inability to communicate with me. So that support system for my parents really was non-existent. So the Supreme Court's decision was, as you know, that I did not need interpreting services, and my parents were stunned to hear this. They had a deaf lawyer who had grown up hearing and signed, but not fluently, not well. And this person had a neurofibromatosis, which caused various tumors to grow, including one on their auditory nerve. So when the tumor was removed, the nerve was cut and they became deaf. And that actually happened when they were in law school. And the problem also caused their face to be somewhat distorted. I would imagine that their speech was probably not quite clear due to the tumors and the facial distortion. But the person was willing to take the case. Again, they didn't have much money because my mom didn't work. So it seemed like it was a good experience. At first, so this was the first deaf attorney to face the Supreme Court. And the Supreme Court didn't know how to provide access to this to this lawyer. So they had the real-time captioning, or court reporting, as it was probably called then, displayed on a larger screen so the lawyer could follow what was happening. And the judges were rather split because I was passing my classes. And what they failed to recognize was that, of course, my mother was doing all of the teaching. The school wasn't teaching me anything. They, again, looked at only a snapshot of my school experience. They did not have a 360 or holistic viewpoint. So that, in fact, was the last interpreter I ever worked with, the coda in 3rd grade. I ended up in 5th grade having a split classroom. One part of the classroom was all boys, and the second class was myself and 4 other girls, as well as 15 other boys. So there is 20 and 20. So I felt lucky to be a girl because I had these the support of these other female students. We had 2 different teachers who were both men. The other group had math classes that I was with just for math. This was Mr. Brett was our teacher, who was another quite large person, and he had an Australian accent. And I'll tell you, that accent made it impossible for me to understand him. So there was a lot of discussion about where I should sit. Should I sit in the front to lip read him better, or should I sit in the back next to his desk so I could talk to him one-on-one? So when the teacher's lectures were done, I could go up to him and ask him in writing what questions that I had. So he and I wrote back and forth a great deal. And I can't say that this was a positive experience. I know that being a teacher in a mainstream classroom with a single deaf student is a big challenge, and that he tried his best. And I've seen other teachers struggle with this. But as a child, I could really see his frustration. One story that I'll share is he would talk about this map project that we were going to do over and over. So it seemed to be this hot topic within our classroom. And one Friday, I remember him saying, yes, we're going to have the maps due Monday. We're going to, maps on Monday was repeated over and over again. And I'm imagining, oh my gosh, we have to finish some sort of map over the weekend. I don't know what it is. So I got home and told my dad, there's maps due Monday. I don't know what I need to do. My dad asked me, what the details were. And I said, I didn't know, the teacher hadn't told me. So my dad took me to the store. We bought a poster board and art materials. We went to the library and checked out an atlas. And I spent the entire weekend, I'm telling you, the whole weekend, drawing this atlas, drawing this huge world map. I was so proud of it. I worked very hard on this map, rolled it up, and took it with me to school. And when I got to school, I saw that I was the only student that had this rolled up poster paper with me. So I got into my classroom and put my poster board next to my desk. And my teacher said something about maps once again. And I'm waiting to see if I should unroll my map. I wasn't sure what to do with this project that I'd spent all weekend on. And my teacher gets this big stack of papers out and starts passing them out to the students. The maps were not, in fact, due on Monday. We were going to do maps on Monday. So I cannot express to you how disappointing and distressing this was for me, that I had spent all this time working on this and I was the only student in class who didn't know what happened. So my dad excitedly asked me when I got home how my map was received, and I told him that it was all a big misunderstanding. And I was so sad that I was so sad about it. I had been so proud of this work, all this work I had done, and turned out it was all for nothing. We would go on field trips. Well, actually, there was this camping trip in the Catskill Mountains. And it was so fun. I really enjoyed it. We learned blacksmithing. We learned how to start a fire. It was really enjoyable. We went hiking. And, there was all this instruction given in spoken English, which of course I missed. And I really wanted access to it. So this was back east, and there's this beautiful white tree that I'm blanking on the name of. I think it's a white birch tree, maybe, where the bark would fall off in large peels. And my teacher could see how much I wanted to have access. So the teacher collected some of this bark, kept it in their pocket, and would write on it the names of things that other students were learning, or deciduous trees, and so on and so on. I actually still have that bark. My mother still has it. Of course, I handed it to my mom when I got home, and she was so astounded by all this effort that this teacher had exerted, all day, every day, writing on little pieces of bark. All that I must have missed, just getting a few words here and there written on bark was really trying. So back to my classroom teacher, I would, again, my desk was near his, and I would go up to him after his lessons and ask for clarification. And he would just continue to use his voice to communicate with me. And I was so frustrated. I couldn't understand him. And his temper was getting higher and higher. One day I just left his desk, went back to my desk, and he pulled the back of my hair. He pulled my hair in order to get my attention, and I started crying, of course, and he apologized and went back to my desk, and I was upset. And of course, I told my parents that my teacher pulled my hair, which, my parents recognized that he and the school and I were all really over it. The school district wouldn't allow me to have an interpreter in the class, but it wasn't them who suffered for it. It was really me and the teachers. My dad, again, was a chemist, and his company actually moved to New Jersey. So my dad had been commuting an hour each way to work. And my parents began to consider moving to New Jersey. And they discovered in New Jersey a large deaf program. So they decided to sell our home, wait until I finished 5th grade, and sell our house. They never put a sign out on the front steps. To know that the house was for sale. Oh, I'm sorry, interpreter correction. No. Yes, they didn't put a sign post out on the front steps. They instead used some service that published that information. Now the school district put a lien on our house for their fees for fighting my parents' case, for whatever fees they paid for their legal fees or whatever. And of course, that's money that my parents absolutely didn't have. They hadn't actually paid their attorney. Their attorney had worked for them pro bono. So all those appeals that the school had filed, they then passed those fees on to my parents. So with this lien on the house, my parents couldn't sell the house. So we actually moved to New Jersey and rented out our house because they couldn't afford to sell it because of the lien. My brother went to school. My brother, again, being the only hearing person in our family, really had a hard time. He didn't get any support from his classmates. He didn't have a good relationship with people in general. He got picked on a great deal for having a deaf family, made fun of for his family being deaf. People made fun of him for the court case, you know, all of those kinds of things. So my parents actually pulled him out and put him in a private Catholic school. But there they found out that his parents were deaf eventually. And once again, the bullying and all of it began again. So they were not finding a good school for my brother as well. So moving to New Jersey, the idea was to find a fresh start for all of us. And for me to be able to go to school where I would have access to an interpreter without any fight. And my brother would be able to go to school where deaf students were not a novelty. Our deaf families were not a novelty. This was my first time having other deaf children in the classroom with me. And I can't even express how amazing that was. Having an interpreter was a given. And my brother didn't tell his classmates that his family was deaf, but once again, they learned of it and they had basically no reaction. And I think that really had an impact on my brother. He got to just be himself instead of being the only hearing child in a family of all deaf people. So even though we lost the case, moving was still better because the situation was very toxic. So leaving was the best thing that happened. So over the years, I've seen how the law has been interpreted and applied in a variety of situations. And I just feel like deaf children and other children with disabilities have so much potential, and appropriate seems to be interpreted as basic, as serviceable. And I'm certainly not happy with that decision. And over the years, the feelings have increased as I have seen other people experience what once might have been considered adequate be knocked down to even less than adequate. So with the Andrew decision, I do feel like we've regained some ground, but I still don't feel that we're entirely where we are or nor where we should be. The Supreme Court decision had a big impact on my life. Even though moving made things much better, I have continued to hold that experience with me. Maybe, trying to think exactly when, 12, maybe? Well, anyway, let's say 15 years ago, a friend of mine someone wrote a book called The Human Right to Language. And a friend alerted me that they talked about me in the Supreme Court case. So I looked for the book, and upon reading it, I felt so validated. I felt like it was finally clear where the Supreme Court had gone wrong, how they really crushed my soul. This really validated that experience. The book focused on the Constitution and the right that I should have as a citizen in the United States to access my country, and how the Supreme Court had denied my right to learn, my right to be an active participant. And again, that book just was so resonant for me and had a really big impact on me. I appreciated the opportunity to meet that lawyer who I have since spoken with many times. And I could go on, but I think now is probably a good time to pause and see if you have some questions.
Good morning, everybody. Amy, June, thank you very much for a really engaging presentation. As I told my classes, it's so important to put a face behind the name, and you've just done an amazing job. You're an engaging speaker in person and equally as engaging online. I'd like to see if anybody in the audience has any questions. I have a few.
Hey, Charlie, I'm so sorry. This is the interpreter. Amy Jean's not able to see me.
Oh, okay, I'm sorry. I'll let the other people up. I'm not technical enough to do that.
If you could just hang on for a second.
Sure, I'm sorry.
Amy June is saying, again, the title of the book is The Human Right to Language. Do you see me? Oh, she sees me now, so we're ready to continue.
Did you hear what I had said originally?
She's saying, no, I didn't have access to
Okay,
that.
no worries, no worries. My apologies. I like to say technology is great when it works, or if it works. But thank you for a wonderful speech. As I've told my classes so often, it's so important to be able to put a real face and a name together, not just a case we read. We tend to reify people. We tend to just talk about the case and we lose the person behind it. You're a very engaging speaker, having spoken together back in Utah some years ago, and I know it's valuable to everybody. I really appreciate you being here. I'm hoping we can get you here in person one day once everything kind of resolves. There is a question from one person, if you knew or would like to comment. Do you know or know of Marcella Meyer?
No, that's not familiar to me.
That was a question from the audience. Since there are no questions, I had one or two for you just to get it started. You mentioned NDREF, which kicks it up a notch, if you will. But if you were on the Supreme Court or if you were in Congress, how would you modify the IDEA to address the needs, not just of children who are deaf, but all kids with disabilities? As I'm sure you know, Congress has not even looked at the IDEA since 2004, and it does not even appear to be on the agenda. Unfortunately, I think it's kind of lost right now. But sooner or later, Congress is going to have to address this important statute. 15% of our kids are on IEPs. Only a small percentage of kids are deaf, but they all need to be served. What suggestions do you have as somebody who's devoted your life to working in this area to strengthening the IDEA, particularly for children who grew up who are hard of hearing and deaf?
Well, of course, I have a lot of thoughts about that. I am the mother of 3 children, 2 of whom are deaf. The third is hearing, but all of them have IEPs. My son, who is hearing, has ADHD. One of my daughters does as well. And I have gone through the IEP process many times, but for different reasons, right? Not for each of my children's IEP processes has been very different. Clearly, one thing that I feel very adamant about is that something that's terribly misunderstood for deaf children, the concept of LRE, least restrictive environment. For deaf children, a mainstream school is in fact the most restrictive environment. Deaf children are not given access to communication in a mainstream situation. They may have a singular channel through one interpreter, but that is not access. That is a bare minimum. So as we see more and more students with cochlear implants, they may have some success in those kinds of environments, but that doesn't necessarily equate to full access by any means. So at a school for the deaf, all of the teachers sign, the principal signs, the lunch staff signs, the janitors sign, and that is full access. That is the least restrictive environment. Clearly the most accessible environment. So I feel that that interpretation of LRE is very misinterpreted as in general. I also feel that parents are the ones who know their child best. I do not believe that the system advocates for parents so much as it allows the school to do business as usual without interruption, without true accommodation. So schools typically will encourage parents to choose a particular method that is not necessarily what's best for the child or what the parents want, but that's what's most efficient for the school. So I don't feel that the system is student-centered, that in fact, we have to fight for a student-centered approach. And it's exhausting having to fight continually.
No doubt.
And sometimes it's just more expedient to let the fight go.
Thank you very much for that. And by the way, Jennifer, I apologize. I was remiss in not thanking you for your service translating for everybody this morning. There is a question from somebody in the audience, and I'll not mention people's names unless they wish me to, but let me just read it to you. I think you've addressed it some, but you might want to elucidate. Do you think that schools taking the position that they fund sports and the like, but only do the minimum for children with disabilities, is a denial of their right to an education? And let me add to that. In your classes, what do you tell your students? When you speak with educators, what do you tell them as a practical matter to try to fight for greater equity and greater funding to meet the needs of kids with disabilities? Because you know from your experience, it's expensive providing these services. Do you have any suggestions in making sure the kids are not denied their educations? Thanks in advance.
Well, give me another hour to talk about this.
I hear it. Amen.
Yeah, I appreciate having everything accessible for a child with disabilities, right? Sports, after school activities, clubs. I certainly appreciate that. And sometimes it's not possible. And when someone does have access to all of the options available, there is nothing comparable to that. I think we should always start with that as the goal, as the intention. And we are seeing a lot more mainstream children succeed and enjoy their educational experience while having a school approach that is more holistic. So they have more access to a variety of aspects of their education. I, growing up, never wanted to be different. I never wanted to highlight that I had a need or that I needed to do something different or needed something different from other people. And I think that's very normal. I think children and young adults don't want to bring that attention to themselves. They don't want to emphasize that they're different in any way. And I'm not comfortable with, when we talk with students and explain things to them, we need to encourage them to advocate for themselves. I think what's ideal is to not expect students to have to do that work, that we should not be seeing IEP goals about children advocating for themselves. My child is a sophomore in high school, and he absolutely will not advocate for himself. He'll do everything to avoid needing that. He's a social butterfly and all of that, but if he has to make himself stand out, if he has to say, I have a need that's not being met like everyone else is in the classroom, he would rather disappear from that situation. I, as a mother, am trying to, advocate for him with the school and say they keep saying though that he's a high school student and he has to do this, but I'm like, this is also part of his disability, that is very challenging for him.
Good luck. We have about 5 minutes left. And I have two questions here in the chat box. So let me ask them both, and I will let you answer them as you see fit. The first question was, why were the fees assessed against your parents? Was it the American rule? And the second one, and I'll read it and then I'll be quiet. Can you see the issue of language barriers for students who are deaf in mainstream schools expanded to children with other types of disabilities? For example, a student who has, in quotes, mild autism or Asperger's may seem, in quotes, fine and able to be educated in the same way as most other children. But the way students interpret what teachers are saying can, as you know, be significantly different, adversely impacting their ability to be successful. Can the work you are doing with language issues for children who are deaf be expanded to help the work of other students with disabilities? And we look forward to your answer. And I think that will be about it for our session when you finish your these questions.
Let's go back to the first question regarding the fees. The school district won the final appeal. So they then had the ability to put a lien on my parents' house. So they shifted that burden, all of their fees, all of their legal expenses to my parents. And they have the ability because they won. Can't answer beyond that. I was 10, I think, so I still don't know exactly. And now I understand liens, of course, and when you can't pay a builder or something, they can put a lien on your house, a construction worker or something, until it's paid off. So I imagine it's the same beyond that. I'm not sure if the laws have changed in that regard, but yeah, my parents were stuck with the school district's legal fees.
How then about the second question, expanding your work to other kids with disabilities? And I think we'll probably end our session with that answer, unless somebody comes in at the last minute. Thank you again in advance.
Certainly. Pleasure. Yes, I do believe that that's a valid question. And when it comes to LRE, or least restrictive environment, it seems to me that I'm not a big fan of a self-contained classroom. I do believe that students should be participatory in, interpreter correction. The LRE is not in favor of a self-contained classroom. It believes that students should be mainstreamed. And I do believe that if students are having full access, if they're understanding and processing information, they should have the ability to process in the moment. If they're pulled out, if it's given to them separately in a different way, that's more burdensome on the child. It's more work for the instructor. It's more work for the student. So that really does defeat the purpose of LRE, to have all these pullouts. And I see a number of situations where schools or the educational structure at large is not a fit for some students. And there are many parents who feel that LRE is wonderful for them, for their child, that their child is able to access school with other people, and that inclusion is happening. But I wouldn't go so far as to say those parents are wrong, but I just don't believe in a one-size-fits-all approach. People tend to, in this situation, apply those 3 words of least restrictive environment in a very standardized way. And unfortunately, that's not effective.
Well put, thanks. I lied. One last quick question came in. You might be able to answer with a yes or no. Did the board ever collect those fees after they put the lien on your house? I have to admit that that's pretty low for them to do that, but did they ever recover any of the money?
My parents couldn't sell their house until they paid it off. So my parents paid it off.
Wow. Do you know how much it was? Not to be too personal.
I don't remember I
No
don't
worries.
remember. I have to ask my parents. I can email you, Charlie, and let you know.
Just a curiosity. Amy June, it's wonderful seeing you again, albeit not in person. You were wonderful in person, just as wonderful here. We're in your debt for putting a face and a name behind what are just dry pages in a book. And we wish you continued success with your family and all of your work. And I say, I hope in the next couple of years we can have you come out live to the University of Dayton. I also thank Jennifer, but we thank you both.
Love
We
to
give
see
you a
you
virtual
again.
round of applause and good luck. I think you've got a flight later on today. Hope you catch it and get home on time. Thank you very much for joining us. You're welcome to stick around and listen to the next speaker. But if you have to go, again, we appreciate it. Thanks for joining and we'll be in touch. Travel safely. Thank you. We will now take a 15-minute break and come back at about 10:30 with John Harrelson. We'll talk about disability accommodations in higher education. Thank you, everybody. We'll see you back shortly. Bye-bye.
Thank you so much.
Thanks, Jennifer.
Mhm.
Good morning, everybody, and welcome back. Again, I'm Charlie Rusto. I have a joint appointment with the Law School and School of Education. It's now my pleasure to introduce to you John Harrelson. John is the Director of Office Learning Resources here at the University of Dayton. And as you can see from the screen in front of me, he will talk for disability law in higher education. John will speak until about 11:30. At that point, we'll stop for a lunch break. As with our previous session and the rest of the day, if you have any questions, I will be monitoring the chat feature, so please send the question to me and I will raise them for John at an appropriate time. John, do you prefer questions at the end or are you okay to take questions as we go through the session?
As we go through is fine. I've purposely left a few minutes at the end to take any last minute questions or ones that people want to wait on.
Okay, super. With that, I will stop my mute and video, or I will mute myself rather and stop the video. And we look forward to hearing from you, but I will be moderating the chat box. And as questions arise, I will raise them to you. Thanks very much. We look forward to hearing you in just a few moments. The stage is yours, so to speak.
Thank you so much. And good morning, everybody. I'm really glad to be here. As Charlie mentioned, I'll be talking about a little bit about disability law, but also really the accommodation process in higher education. Some of it will be very general and how higher ed generally handles it. And some of it will be specific to the University of Dayton. Obviously, that's where we are, where I work, and where I can speak with the most authority about how we do things. But we do try to follow best practices. So you'll see that most of what we do at the University of Dayton is not going to be all that different from what's done at other institutions of higher education, at least in the United States. So just by means of a quick introduction here, as Charlie said, my name is John Harrelson. I'm the Director of the Office of Learning Resources here at the University of Dayton. I'm also an alum of the University of Dayton, so I always like to put that full disclosure out. If I speak a little bit too passionately about my alma mater, it's because I was blessed enough to go here for undergrad and then return to work. Graduated in 2010 with a BA, and then I also went to Loyola University Chicago for a Master's of Higher Education Administration, graduating in 2012. Since then, I've worked at a number of large and small institutions before landing back here at the University of Dayton in 2020. So a little bit of a quick overview here. So we'll talk briefly about some of the applicable laws that we look at in higher education when talking about determining disability and accommodations and kind of how that works. we'll talk for a little bit about the difference between higher education and K-12, how we have really a different approach, a bit of a different mindset, and kind of that difference of access versus appropriateness, right? So obviously just hearing from Dr. Rowley and the idea of FAPE and kind of all that's involved in that, and how higher ed really takes an access approach. I think it's always worthwhile to talk about where some of the pushback is on accommodations at the higher education level. As much as we want to think that once they get to post-secondary education, it's all smooth sailing, there is a number of areas where we get pushback. And then I'll just spend not very long, but a little bit talking about what are some of our common accommodations. So rather than keeping us all at a very high theoretical level, we can actually talk about what are some of the specific accommodations that we give at the higher education level, specifically here at the University of Dayton, and a very brief case study of a very recent case that we've been dealing with here that actually is very illustrative of the types of situations that we might face. And of course, I said I'll leave time for questions. So anyway, to get started here, one of the most driving laws, if you will, that informs our work, right, is obviously the ADA. But I add here that it's, as of the amendments of 2008, right? So ADA 1990, kind of a well-known law at that point. But the amendments of 2008 really helped to fine-tune a lot of the things that we look at in the higher ed space. Specifically, right, since both with Section 504, with IDEA, with ADA, there's all these number of court cases, these SCOTUS rulings, and so on and so forth. And kind of every time it goes through the court process, right, there's these tests that get added, these interpretations that get added and placed on top of them. And so as all of those keep getting added on, it starts to tweak and change what some of these definitions are, right? And so with the amendment of 2008 that comes out, it's this idea of, Congress wants to reject some of these heightened standards that get added and create what is the kind of original interpretation that Congress wanted when ADA was originally passed. So one of the revisions is to Title I, right? And it reaffirms, and I'm paraphrasing a little bit here, right? But the primary purpose is to make it easier for people with disabilities to obtain the protections under ADA. So that's really important because it really reaffirms kind of our work, which is not to put strenuous tests on students in higher ed who are looking for these protections, right? That we don't have to have these very high barriers to entry, that it is an access-oriented law, and that we should be looking for what are the areas, what are the ways that we can make it easier for students to obtain their legally mandated protections, right? And then there's additionally changes to titles, 1, 2, and 3 of the ADA. Obviously, right, as it goes into the US code, we get these title numbers, where it helps to clarify these kind of 3 parts, right? Who's entitled to protection, who's entitled to accommodations, and how those decisions are made. So again, attempting to reject these purity tests, these heightened tests and standards, and really clarify who's protected, who is entitled to the accommodations, and how do we get there. A lot of the things that you'll see me quoting from, just as a quick point to the reference at the bottom here, come from AHEAD. This is the Association of Higher Education and Disabilities. It's the primary professional organization for higher education disability professionals. They do a ton of advocacy work and legal interpretation for us, so we're really grateful to partner with them. And they have some really great white papers on their website where they go through exactly right how some of these laws have changed and how we can interpret them in the best way possible. In addition to this ADA and the 2008 amendment, right? We also obviously have Section 504, so not a new law by any standards, and this obviously has this federal financial tie-in with 504. And where it gets interesting, right, is some of the first times I remember hearing about this, I thought, well, 504 wouldn't apply, certainly not to a private school, right? And we don't have federal universities, but as all except for maybe 1 or 2 universities in this country take federal financial aid, that does apply, right? So that is one of the stipulations, right, is that now we're a federal aid recipient. We are authorized to distribute that aid to our students. So therefore we fall under the rules and regulations of 504. In addition to that, even if we didn't, we need to be familiar with it, right? Our students come to us oftentimes with not only an IEP from their high school to say, hey, here's what I received at the secondary level. Can I get this, or can this help me in the post-secondary? But they also come with 504 plans, right? So those 504 plans, right, providing for those accommodations, ensuring success, ensuring access, right? Those things that are less strict than an IEP. Students often bring those in with them in an attempt to get accommodations here at the post-secondary level. So us being familiar with that is helpful. And obviously, right, the mechanisms of enforcement, the similar spirit is all kind of still there with the ADA. So 504 and the ADA are really our kind of 1-2 punch as to where we look for what are our obligations and what should we be searching for in the law to make sure that we're doing our jobs appropriately. So I mentioned briefly enforcement there. It's worth mentioning, right, that the Office of Civil Rights, the OCR of the Department of Ed, is our primary enforcement body for these issues of accommodations. OCR has authority to investigate any disability-related discrimination under Title II of ADA and also Section 504. So we are, constantly kind of aware of their presence and what they will be looking at, what they may be paying attention to or ready to look at if we fail to accommodate or maybe even inadvertently discriminate against a student. In addition to investigative authority, they can also force compliance, right? They have a number of ways that they can do that. Generally, after they will complete an investigation, they will issue a letter of findings, and they basically will seek a mutually agreed to resolution, right? So they will look at, can we resolve the issue? Can all parties kind of get on board? Can it lead to not causing issues in the future? But ultimately, if the university basically were to say, no, we really think that you erred in your findings, it's up to OCR at that point how they want to proceed. There's some administrative things that they can do, or they can ultimately make a referral to the Department of Justice to attempt to proceed that way, right? So we always hope we don't get to that point, but that is the kind of the OCR path. They can also monitor indefinitely. So if you want to talk about what might keep me up at night, right, is this idea of constant monitoring and checking in by OCR for something. There's no real rule as to how long they have to monitor or can monitor. They set the timetable on that to make sure that you are being compliant and that you're maybe not slipping into an old way, as it were, where you're not going to be as compliant as they want you to be. So while these are the laws and the kind of the enforcement mechanism, there's constant updates, right, that are happening as what we look at and what's kind of applicable to us. So the first is through OCR decisions. So as these decisions get made across the country, right, several hundred schools, 1,000 schools across the country that may occasionally run afoul of OCR or lead to an investigation. These decisions get published. These letters of findings are not private. OCR is very specific in making sure that that nobody quotes them or cites them in a lawsuit or anything, right? They're not matters of kind of case law, but the OCR decisions can offer a lot of insight into these difficult questions of reasonableness, right? What was reasonable? Did the university, did the higher education institution make a reasonable decision? And they, I say they can serve as an early warning system, right? Because even though it's not a exact quotable, citable rule, it is something to pay attention to, because if OCR found that a university did something and maybe we do something very similarly, we're going to pay attention to that. So we have a great publication called Disability Compliance, comes out once a month. It summarizes all of the OCR rulings from the last month. So we read that religiously to stay on top of those and to gain insight into things that maybe we hadn't considered. To give you a very specific example, one from this past September issue is incredibly relevant. It comes out of Salt Lake Community College, and a student was pregnant and was seeking some temporary accommodations based on pregnancy-related symptoms, right? not a year ago here at the University of Dayton, we had a student who came forward and said, I'm pregnant, I'm having horrible morning sickness, some of those early first trimester symptoms, and I would like accommodations. And we had a really robust conversation amongst a lot of people here about some of the older interpretations, right? Which is pregnancy a disability, right? Are those temporary symptoms, do they constitute disability or not, right? We ultimately, decided here to go ahead and support the student, right? Regardless if it was the legal thing to do, we felt it was the morally right thing to do. Salt Lake Community College didn't. They said that it's not a disability, and so therefore they're not eligible for those protections. Student went to OCR, raised a complaint, and OCR found in favor of the student and said no, they needed to provide protections for them. So even though that's one we had kind of already resolved, it was really interesting to see something that we had just been discussing about a year ago that OCR has now weighed in on. So now we have even more reason to follow kind of our gut on that, which is to provide those protections for the student. The other piece of it, right, is case law. So while OCR decisions are great, case law is a little bit more of a gold standard in terms of getting those detailed reasoned opinions from the courts. So being able to see, are there new tests that we should be, looking at? Are there things that that give a rationale, right? That help us to interpret the law just that much better. Sometimes they do come actually from an OCR complaint, right? So a student may go to OCR and say, hey, I believe I've been discriminated against, or the university's not properly accommodating me. And the OCR investigation finds no, the student's claim was without merit. That doesn't stop the student from filing, a civil action against the university. And then so, it could be OCR related or it could not be OCR related. But anyway, that case law is also helpful. Again, that comes into us through the compliance newsletter that we subscribe to and also through AHEAD. So getting into kind of the meat of this difference, right, between higher education and K-12, most institutions of higher education, there are some exceptions, small schools, small private schools where somebody may wear multiple hats and not have the specific title, but it would be a DSO, right, a disability services office at a larger institution. University of Dayton has an entire office, or a disability services official at maybe a very small school, private school, for instance. And basically their job is to ensure that students are constantly being accommodated, right? That we're interpreting these laws and regulations correctly and getting the accommodations to the student. Where I think the key differences between higher ed and K-12 is the approach that we take. So when I say that we take an access approach, it is really about student-driven access, right? Creating equal access, creating effective access, creating meaningful access. These are phrases that are used constantly in the literature around how we should be looking at accommodations. So, and I think of the wonderful, talk that we just got from Dr. Rowley, and so much of how we would approach it in higher ed is fundamentally different, right, from how her experience was. Now, I understand that was a number of years ago, but still higher education looks at what are the barriers that the student is facing. And so to use her example, right, which is so spot on about needing that communication, right, better communication in the classroom, right, that would be the barrier. How do we remove that barrier? If we had said we will put a CART interpreter, somebody who can do real-time captioning and transcription, and the student said, actually, that's not what I need, we would go ahead and say, okay, what do you need, right? What is going to be appropriate for you to help remove that barrier of communication? And
John,
so that's why
may I interject with two questions from the audience? I'd
please.
try to give you a little bit. Let me read them both to you, and I'll let you answer them as you prefer. The first question is, what advice do you have for students regarding how to get their disabilities accommodated if their conditions were never addressed in high school, and so they don't have a 504 plan? Of course, IEPs do not cover. For what it's worth, just by way of background, a few years ago, one of my PhD students, who's a counselor, did his dissertation over here in educational leadership on stigma attached to college students who did not want to reveal their impairments with regard to psychological issues and emotional issues. So that's the first question. The second, just an FYI, Sinclair Community College gave this person a permit to park in a handicap spot closer to the building when she notified them that she was pregnant. So I'll let you speak on those two, and I'll get back off the screen. Just as a heads up, if you see me pop up,
Not a problem at all.
Gonna be raising a question.
That's all. That's totally fine with me. Okay, I see the quote here, so I can read it here about Sinclair. So real quick on the Sinclair, yeah, it's really fascinating. We're actually just a little peek behind the curtain. We're in a really interesting conversation at the moment here at the University of Dayton with our parking services about the issuance of handicap or disability permits, and if they accompany a state placard, right? So if they've gone to the trouble, a student's gone to the trouble to get a state issue disability placard, right, to park at Kroger or Meijer, you know, any store, any doctor's office, what's our equivalent response here at the university? And so it's a really interesting conversation that we're having about that to make sure that we're meeting, right, not only our legal obligations, but again, we feel a certain moral obligation. Are we doing what's best for the students? So it's really interesting about Sinclair, and yeah, we would I almost certainly follow a very similar protocol in that way. The other question about advice for students to get, yeah, I'm actually going to come to that in a little bit. There is also, I really will come to this, but it is incumbent upon us as higher education disability professionals to not use the IEP and the 504 plan as a crutch, right? There's so much more that we should be doing first before we even look at that documentation. It's fairly standard that students walk in. When I staff resource fairs and orientations, a lot of what I'll say is, do you have an IEP? Do you have a 504? Because it's very common. But I always try to say, even if you don't, did you have other accommodations, right? Because any evidence of accommodations in the past is to be given a lot of weight per some of the ruling and guidance we've gotten. That IEP and 504 is supplemental documentation. So if I haven't fully answered that, I'm going to get to that in a few slides, and then certainly don't hesitate to jump back in and make sure that I come back and fully answer that question here in a minute. So anyway, we were talking about students taking the lead, right? We talk about kind of identifying those barriers. And so part of, right, what we are expected to do is, as we seek information from the student, is to establish what is that eligibility, to understand the impacts of that disability, and then to make those informed decisions to ensure we provide effective access. So again, we keep coming back to effective access, meaningful access, right? What is the way that we best provide access, not what is the way that doesn't put the University of Dayton out or doesn't cause the most financial harm or anything like that, but how do we provide appropriate access for the student? And so I threw in here this example, and I actually did this while I was listening to Dr. Rowley because it struck me as a really recent example. So we have a student here, we'll call her Sarah, that's not her real name, but she approached us this summer and said, I am deaf. She has a cochlear implant, so she does okay with kind of one-on-one conversation. She lip reads and hears some level of audio. And so we told her, okay, well, normally we would start with CART. Is that okay with you? Do you want a transcriptionist in all of your classes? That's what we've done in the past. And she said, no, I sign, and that is how I best participate in class. Without hesitation, we said, no CART, you get an interpreter, right? Because the student took the lead. I'm sorry, we allowed the student to take the lead. We said, what is it that you have a need for? If your need is not for CART, but is for an ASL interpreter in the class, then that's what we're going to provide you. So I don't say that as a way to kind of toot our own horn, but it didn't even occur to us that that would be a groundbreaking thing to do. We looked at the student and let them take the lead on what is going to provide you the best access. So I threw that in at the last minute because I thought, oh, that's so, kind of tantamount to what we're talking about today. So to get actually to a little bit of that question that we were just looking at, right? So that determination of a disability, federal regulations don't require us to request or obtain documentation. That is a very old school way. Some universities may have that on their website, right? You must provide documentation. That is not what current federal regulations say and not what best practices say. We may request reasonable levels of documentation, especially if something is not very obvious, right? So the most easy example that I give, especially when I'm training staff, when I'm giving talks, is if a student comes in on crutches with their leg, you know, in a boot or a cast, we don't need to ask them, did you break your leg? Can you provide documentation that you broke your leg? We can just start giving them the accommodations because it's right in front of us. If the student comes in and wants to talk about, I have dyslexia and it's really challenging for me to do X, Y, or Z because of this disability, that's going to be really hard for us to observe. So some level of documentation may be really helpful in illustrating what is it that the student has, what is it that they need. And I talk about it's very common for students just to volunteer. I have an IEP, I have a 504, I have something from my school.
John, another question, if you don't
Yeah,
mind.
please.
Is the disability compliance monthly report you referred to available to others to sign up for and what have you? And if so, could you please provide the website address either to me or to Leanne, or if it's short enough, you can speak it out and the person could get it. Thanks very much.
Yeah, absolutely. So I'll make sure to provide that definitely after. It is Disability Compliance is the name of the newsletter. It's issued monthly. I was looking to see if I have a copy on my desk. I don't. It is issued by Wiley and Sons, is the publishing house. So here at the university, we get it through our library. They have a subscription to most of the major publishing houses and their publications, but it can be subscribed to as well through their website. But it is called Disability Compliance is the name of the newsletter. It's a purple shade on the every issue. But I'll provide the exact link after to Leanne and to Charlie. I really love this quote because I think it really helps set exactly where higher ed is on this, right? And this again comes from a head. Requiring extensive medical and scientific evidence perpetuates a deviance model of disability, undervalues the individual's history and experience with disability, and is inappropriate and burdensome under the revised statute and regulations. So I look at this a lot to say, are we inappropriate when we ask a student to give us documentation, right? Are we really making a burden on the student? And that's not just a burden on their ability to dig out the documentation. We have students who are Pell eligible, right? Who are of a very low socioeconomic status, who may not have had access to substantial testing, right? Maybe they've always struggled and they weren't accommodated in high school because they didn't know. They were never diagnosed and they never had anybody to speak up and advocate for them. So, but just because they come in without that magic, you know, packet of papers, we really should not look at that and say, oh, you don't have that, you're not going to be eligible for accommodations. And so we really say, you know, that each determination should be highly individualized and not follow strict checkbox guidelines. So the key here is that just because, as I mentioned with this student, Sarah, right, who is deaf and hard of hearing, just because she comes in and checkboxes I am deaf does not mean that she gets a CART service, right? She gets what would be best for her, which in her case is an ASL interpreter. When we look at the kind of the listing of documentation, right, we would say our primary documentation is a student self-report, not the IEP, not the 504, right? It is what the student tells us, how they're limited by that impairment. We do it in an interview with one of the professionals in the office. Our staff get a lot of training. They attend the conferences that a head puts on. They attend webinars to constantly stay updated and fresh on best practices. But some schools could do it via questionnaire or an intake form. But that interview style allows us to have a back and forth conversation. And it really feeds into the secondary documentation piece, which is that these impressions, conclusions, observations, interactions from that meeting are so critically helpful. I can tell you that it's incredibly validating, right? So to Charlie's point, actually from earlier when we had Dr. Rowley on, I was so taken with her presentation because I've read her case, right, at least twice before, and it's words on a page, right? When you read some of these IEPs and 504 plans and medical documentation, it becomes so easy to become numb to it. Okay, they have ADD. Okay, they have ADHD. Okay, they have autism, right? But when you actually meet with the student and you hear their experience and you hear what has worked for them, that they constantly try to give me extra time. I find the extra time more distracting. I'd rather keep the time that everybody else has in the test. That is so much more powerful than just reading a document and slapping an accommodation on a student. So we really try to do that 1-2 punch, right? What is it that the student reports, and what do we get? What are our observations and conclusions? And how do we connect those dots while going through that? And then that kind of tertiary piece is those external sources, right? Those IEPs, those 504s, medical records, reports and assessments from guidance counselors. We've gotten letters from teachers in post-secondary saying, it's a private school. We don't do IEPs. We don't do 504 plans, but here's what we did for the student, right? Sometimes those can be incredibly helpful. Sometimes not so much. It just really depends on what we hear. We also try and build a really holistic view of the student. So sometimes we'll reach out to some of our partners across the institution, right? We'll reach out to their current instructors. We'll reach out to the residence life staff and the dormitories to say, what are you observing, and how can we help take that into account as we build a fuller picture of the student to determine what is the most appropriate forms of accommodation for them. So then we get to this question, right, that was kind of prompted in the chat. What if there's no documentation at all, right? The student comes to us and just says, I have nothing. Title III regulations basically say you should give considerable weight to documentation of past accommodations. That's good, right? We want to look at what has worked for the student in the past and try and mimic that as best we can going into the future. There's been guidance that has come out of the Department of Justice in recent years that has said, don't read that too literally, right? Don't read that to mean that just because they don't have that documentation, they should be excluded. So as I've been talking about this, right, that we look at the student self-report, that we look at what we observe ourselves, what our colleagues across campus might observe, that should also supplement and in time sometimes outweigh that. The one thing I've told parents specifically when they've come in and said, we went to Catholic school, right? That's a very common one for us. And they did not issue an IEP. What do we do? How do we get accommodations? I say, come have a meeting with us, right? Talk to us. Tell us what worked for you. Tell us what was helpful for you. There's no reason for us to throw up barriers and kind of these artificial walls if you can explain to us what it was that was helpful and how we can help provide that accommodation going forward. All right, so up to this point, right, we've determined the student has a disability, so they are now eligible for those accommodations. So what do we do now? So when we start looking at accommodations at the higher education post-secondary level, we want it to be highly individualized. So similar to how we really were trying to talk one-on-one with the student and determining their eligibility for the accommodation, we want to do the same thing. There is no one-to-one correspondence. There are commonalities, right? If you were to just blank tell me, I have ADD, I have ADHD, I'm going to, in my head, think of the top 3, 4, or 5 accommodations that are very common for students with that disability. However, as I mentioned earlier, it's possible that in conversation with the student, they say, I actually find that more anxiety producing, right? Taking a test out of the classroom in a private room where it's just me and my thoughts and there's nobody else in the room. Yes, I have ADD. No, that is not a helpful accommodation, right? So we would say, okay, let's not use that one, right? And it's not an all or nothing. So a student doesn't have to say, I don't want that today, and they can't come back and get it tomorrow. So we do allow students to constantly reassess and come back to us and say, now I actually want to adjust. This didn't work for me. I thought it would, it didn't. What can we do differently? In higher education, there is one key word to all of this, and that's reasonableness, right? So accommodations are meant to provide meaningful access, as we've talked about, to all facets of higher ed. This is academic and non-academic, right? So we have to look at what are the other parts of the experience of being a college student, and how do we provide accommodation? So it's not just in the classroom, it's every aspect of their life as a college student. So we use this litmus test, right, of reasonableness to say, how do we determine if that accommodation, if that request that you're making is fundamentally reasonable? It really depends on the individual application, right? So obviously something that happens in the classroom versus something that happens in a housing situation are going to be two totally different experiences. in the classroom, which is primarily, right, what a lot of our accommodations are driven towards, it hinges on whether or not the accommodation would fundamentally alter the curriculum or the learning outcome. We could kind of look at that in two different ways. We take a very careful approach to make sure that we defend the curriculum, right? So while we are advocates for students with disabilities, that is our primary role, we also are part of the university, right? We're part of higher education and wanting to make sure that we defend the fact that there is some reasonableness to say you must accomplish certain outcomes, right? You must participate in the curriculum as it's defined. So there's a real tension there that we're constantly in the middle of between defending the student and advocating for the student while also trying to make sure that we defend the integrity of the program, defend the integrity of the curriculum. So an example that's a very real example, we've dealt with it a number of times, right? Is a student who takes a public speaking course. They have an anxiety disorder, they suffer panic attacks, right? So lots of anxiety provoking things that could happen in that class. And they may say, I can't do any of the assignments in which I have to speak publicly. I will get sick. I will have to throw up. I will completely shut down or be shaking so badly I can't give that speech. So they may say, that's what I'd like. I'd like to take the class. I'd like to study everything, but I don't want to give any speeches. Is that a reasonable accommodation, right? And the answer is it depends. So there's always a lot of grayness with this. We have to assess reasonableness on a case-by-case basis. So I can tell you that one of our staff in the office here at the University of Dayton is very much a black and white thinker. They're like, well, if it worked for that, it has to work for this. And so we're always kind of talking about it's always case by case. It depends on the individual student and the individual class. And this, is a bit of a paraphrase from ahead here, but that reasonableness should take into account the unique attributes of the requirements of the course, the program, or the activity. So we don't want to make it so, universal, so one-to-one, that we don't take into account what may be happening in that particular course and that particular program. What we also have to look at then is, are these modifications, are these auxiliary aids constituting a fundamental alteration, right? If they're a fundamental alteration, they're not considered reasonable anymore. And that can be both good and bad, right? The alteration may be so great that it no longer, the curriculum has been, unduly affected, right? And the alteration could be so low that we haven't actually done anything to help the student, and therefore we're not even accommodating them. So the ADA, right, it's always just helpful to remember, establishes that floor rather than the ceiling of protection. What is the minimum that we have to do to make sure we're meeting the letter of the law? And then the ceiling, right, is hit when we've said, okay, that next thing, that would fundamentally alter the course or the program of study. So that's where we've hit the top on this, but not, we always want to stay above the floor. So somewhere in the middle is the sweet spot. So to go back to this example, right, of this public speaking course, if we look at the core learning outcome of this course, and it is to speak publicly in front of the class, would be public speaking, it'd be really difficult for us to argue that that's a reasonable accommodation for the student to not have to do that. On the other hand, if that's only one of the outcomes, if there's all kinds of learning outcomes about research about speeches, about the mechanics of public speaking, of the outlining that you have to do, of any number of these pieces of a presentation, right? And the student says, look, I can do all of that, I just can't give that speech. We'd work with the faculty member. Hey, are there ways that we could find another way around this? Could the student give the speech just one-on-one to you? That would be considered reasonable, perhaps, right? Because we could say that we're still honoring the core crux of the course, right? It's still reasonable that the student will be participating in the course. This one element they fundamentally can't do, but we're not betraying kind of the curriculum and the learning outcomes in that way. A couple of the challenges, although I see the Q&A has popped a couple times. So Charlie, I don't know if you want me to pause here or not.
Can you read them, John, or do you want me to read them if you're looking
I
at
can grab them. I don't mind. Okay, so there's just a follow up on the.
Yeah, let me read it. Let me read it
Yeah,
because
please.
not everybody's seen them.
Sure.
2 questions. First one, I should have stated that earlier when I brought up Sinclair, this was 18 years ago. So it's interesting that almost 2 decades later, institutions are trying to figure it out. I must have encountered someone very nice and forward thinking at Sinclair. Second, from the same person, following up, I'd like to be more specific because I believe I've heard advice for students with documentation and for students without documentation, but actually had accommodations in high school. What's the advice for students with disabilities who were never documented or accommodated in any way in high school? For example, a student medically diagnosed with Asperger's who never brought his condition up in school, so he just did very poorly in high school.
Yeah, that's a
thanks.
Yeah, that's a great question. So if a student has not received any documentation or accommodations, right? So they are completely starting kind of fresh, if you will, at the post-secondary environment. Number of things that we would look at. Generally speaking, right, it's best to go through kind of that primary, secondary, tertiary workflow, right? So first and foremost, going in and meeting with that disability services office is going to be the student self-report. Now, ultimately, right, at some point they have to say, I have this disability, right? I have Asperger's, I am on the autism spectrum disorder, something that gives us that starting point. We will do research. We will look into what are common things. Maybe the student comes in and says, I don't even know what to ask for. I just know I have this and everything is tough. If we're not familiar with it, first thing we're going to do is say, give us a day, let us dig in and do some research, talk to some of our peer colleagues and find out what are common accommodations, what would be considered helpful, and let's start trying things out. So again, because we're access driven, we're going to say, let's try these 5 things. Come back and talk to us in 3 or 4 weeks and tell us if that's helped. Tell us if that's worked for you. I can't say that every institution is going to have that open-minded of an idea. That's definitely what we do. That's what best practices say we do. That's what AHEAD says we should do. But that's where, right, the student coming forward and explaining what they have and then participating in the process. So again, it's student-led. We don't want to tell a student with autism who's never had accommodations, these are the 5 accommodations that you get, good luck. We want to say, here's 5 we think you should try, see how they work, come back, tell us what's not working, let's tweak them, let's modify them, do what we need to do, and then we'll come back and try something different if that's not working. So even with no documentation at all, even with no prior history of accommodations, it's still very possible, very likely that a student can get the accommodations that they need. My case study at the very end here, if we have time to get to it, is actually a student who also has no diagnosis of a disability. And so, I'll just jump into it really quickly. Student basically came in with no diagnosis, no documentation, no history of accommodations at any level, just has always struggled. And it was a kind of a new one for us to have nothing, right, to start completely from scratch with a student. But basically, the student's self-report is, I've always known something's wrong. I feel like I have ADD, ADHD. I feel like I have anxiety. I feel like I have depression or major depressive disorder, but I've never been diagnosed and I'm not 100% sure what to do, right? And so in that case, right, we went into that second phase, right? Okay, what are our observations? The observations of the professional who met with the student were the student was very truthful, was having a hard time articulating the struggles they've had. And so we went into what would then be some accommodations that we could start putting in place. But we also recommended the student in this case to go and seek formal diagnosis, right? There are things that may be helpful to you, medications, therapies, treatments. And so we don't want your accommodations to be kind of the end goal of this. We want you to be a healthier, better, happier person. And so we're going to put these accommodations in place immediately, but recommend strongly that you go ahead and get that diagnosis for your own betterment and your own self-help. So we can do that really, from any stage in that process, but that was fairly rare that we had a student who had absolutely no documentation whatsoever, had never been diagnosed or even seen anybody.
John, as I listened to you, a thought came up.
Please.
As you may know, I teach a course on higher ed law over here in the School of Ed,
I do.
and I may try to offer a 1 hour course in the law school, but a thought that comes up, which I often receive from students here, how much do you do with incoming students? Or what kind of information do you provide students who may be unaware of what their rights are, who some of the kids you've talked about, who, for lack of a better term, are falling between the cracks? Do you meet with kids at orientation? Do you put out emails to them? What kind of outreach do you guys do? Everything I hear is that your office does a wonderful job. I'm just wondering if you can be a little specific,
Yeah,
fill me in and others who are listening. And
sure.
by the way, what John is talking about, I think is relatively common on campuses. UD does a great job, but this is pretty much what all schools have to do to stay compliant. But I'll stop talking and let you answer, John.
Yeah, absolutely. It is definitely an older approach to kind of let the students come to you. So many universities and higher ed institutions have taken this approach of, if you're a disability services office, they're going to come find you one way or the other. We've really tried to come into a more modern view of that here at the University of Dayton, that there are these students who don't know, right? There is a study I just read, and I'm struggling to remember who put it out. It might have been the Chronicle of Higher Education, where they did some surveying and found that there is a whole, 1/3 of college students who have a disability but don't seek accommodations, right? Whether it's through shame, through stigma, whether it's because they feel like they have it well enough under control that they don't need accommodations, any number of reasons. So what we're trying to do now is put ourselves out there a lot more forcefully. We go to orientations, right? We do presentations with our admissions colleagues to say, if you have students who even mention it, even think about it during the admissions process, direct them to us, let us have that conversation. We try to put a lot of stuff out on our website that is very outward facing so that students can feel ease of coming in, and it doesn't say, have an IEP or 504, come see us. It says, what can we do to help? Let's have a conversation with you. So it's really been a change in approach over the last couple of years and decade or so, to be more forthright with students that whatever you have, come talk to us. If we determine that, an accommodation isn't appropriate, or you don't want an accommodation at this point, no harm, no foul, but at least let's have that conversation and kind of get started with the process. So I'm gonna run through a couple of these last slides here, just a few more. Some of the challenges in higher ed that are really interesting, right, are the fact that, unlike a K-12 in most cases, right, where we kind of just have the classroom and that's the end of it, we have a very wide variety of things that we have to accommodate. So in addition to the classroom and testing, which are, very similar to K-12, we have housing, we have residence halls, right, and have to look at, what does the Fair Housing Act say and how are we staying compliant with that, right? We have dining halls that are serving food, and what needs do we have there? We have a campus, right? Any higher education institution that has a campus may have students who have a difficult time navigating that campus. So here at the University of Dayton, right, we have a dormitory high up on a hill, and we have a building on the far other corner that it would take a solid 20 minutes to get between, and up a hill no less. So what are those things that we have to think about with transportation? Parking, we've kind of mentioned. We have parking lots and students with cars, right? And also these emotional support animals. So while these may be present in K-12, the combination of animals in classrooms, in dining halls, in residence halls is a lot that we have to try and navigate. So it is a very wide scope that we're looking at when we're talking about accommodations at this level. We've talked about this. Students have to self-advocate, right? I completely was empathetic with the point during the Q&A that Dr. Rowley made about this idea that, self-advocacy can be really difficult and that parents should be able to get involved. We don't shy away from parent involvement in that, but we do want to, think about the developmentally appropriateness of having students start speaking for themselves, because eventually, right, they're going to have to do it in kind of their professional life in the real world. So we use college as a very structured, safe environment for them to self-advocate, where there are still a number of safety nets and guardrails. But to start kind of weaning them off of that, a parent is always going to speak for you, where they can learn to start speaking for themselves. And that's really critical with the failure to accommodate. So if a faculty member, if an office, if somebody is failing to accommodate, we're not going to know, right? We're a small office relative to the student population. We can't be everywhere at once. So in order for somebody to say, I've been discriminated against, I've not been accommodated, they have to report that to us. So that way we can go ahead and investigate and kind of move forward. And the last challenge on the slide that just to briefly touch about is the academic freedom of the academy, right? A lot of faculty are brought up and trained in the style of they own their classroom. So there is a little bit of a trickiness sometimes in feeling that out with faculty to make sure that they understand there are some legal accommodations that they have to do while also respecting their autonomy to run their class as they see fit.
John, another question just came in that I think ties in with your notion and that Amy Rowley spoke about of speaking up for oneself. This person asked about accommodations and allergies. How does that work on campus? Because an allergy, I think, unlike some of the things you've spoken about, such as a broken leg or broken arm, we're not going to see the allergy. It's kind of a silent condition. Right. How do you, what advice do you offer for this person and others who are faced with that situation? There's a case from Missouri that's a footnote in my textbook that was found not to be a reasonable accommodation. A student and her parents asked for a scent-free environment in school. They wanted no deodorants or perfume or aftershave. And the court ruled that was not a reasonable request. But let's see what you've got to say. Thanks.
Yeah, absolutely. Where we hear it a lot with allergies is number one in the dining halls. So it's tricky, right? Because on one hand, we would assert that our food services personnel are following all the proper, protocols and things that they have to do, but we'll have students that come up and say, I definitely just got sick eating a salad because it had something in it through cross-contamination, right? And so that we have this kind of fine line that we have to weave through, which is how do we advocate and make sure that we are providing an appropriate accommodation for the student while also not, basically openly admitting that our food services folks just committed cross-contamination, right? That could have much bigger problems for us. And another one that we hear a lot is we have old buildings here at the University of Dayton, right? Some of them built in the late 1800s, early 1900s. What are the allergens that are present in those buildings, right? What are the mold situations and things like that? So basically what we try to do is work with the student on what we can do that will meet their needs, right? So a student who has such a high level of food allergies, we have modified their meal plan to provide them with a kitchen. If we don't feel confident in our ability to successfully navigate that, right? If they say, well, I'm gluten intolerant, we know that we have so many options on a daily basis, right, that are gluten-free, they can likely navigate our food services okay. If they say, I have a extreme reaction to even the scent of peanuts or any tree nuts, it will send me into anaphylactic shock, it's probably not safe for them to go into the dining hall. So we would immediately move to remove them from that environment and get them some sort of residence or housing that has a kitchen that they can keep clean, that they can provide their, source their own food, cook their own food, things like that. The allergens in the halls are difficult, right? It's an air test, right, is only good at the moment you take it. So we struggle with that one, just to be honest with you, a lot to figure out, is the allergen present, right? Is the reaction actually happening in real time? Did they bring it from somewhere else? So on and so forth. So that is a great challenge of ours. Where possible, we try to honor the student's request. We now have a number of our residences that are carpet-free, so we can at least eliminate any ability of carpet to hold on to those dust mites, those allergens, that mold that may be present, and to at least eliminate some of those factors as best we can. So last couple slides here. And please feel free to continue asking questions in the chat. I do joke, right, that every disability services office fears the letters OCR, right? So they are the enforcement mechanism. But even when we're doing the right thing and we are trying and we are doing it with the best of intentions, right, an OCR investigation can crop up. against us where we are, they're looking at something and saying that actually was discriminatory what you did. It is a fairly lengthy process. I've been at an institution that went through one. They're not terribly fun, and they can have a lasting impact, right? Sometimes good, sometimes we learn something and we correct a flawed method, but sometimes they can be really negative. Maybe it's a lengthy investigation that ultimately finds that the university wasn't at fault. And so that can really slow down a lot of things that we do. We can make changes thinking that that we were at fault, and it can take, over a year for an investigation to totally wrap up, depending on the complexities of it. Another one from a very old-fashioned trope, right? We've traced the call. It's coming from inside the house. Sometimes our arguments are with ourselves on this, right? So sometimes we face challenges, not just from our students and parents, but from internal forces, right? So we could have faculty who are unwilling to accommodate in their course. That would be an access issue and a challenge. We also have staff sometimes that push back and say, what we're trying to do to help a student, what the student is requesting and has been granted as an accommodation is an undue burden on them. And then sometimes it's even at the higher level. We don't get this here, thankfully, at the University of Dayton, but I've worked at other institutions where the administration's not willing to resource the office or the accommodations, right? Saying, we actually don't have the funds to provide for an interpreter. CART is cheaper, let's just provide that service, right? So making it cost-centered rather than student-centered can be an access issue that can be difficult to overcome at times. So I'll rhetorically ask you all if you can guess the amount of times a higher education institution has succeeded in a lawsuit where they've claimed that the cost of accommodations were an undue burden on the institution. And if my framing of that is not clear enough, the answer is 0. So there are a number of times where universities and colleges have claimed that in court that it wasn't actually cost responsible, right? It was an undue burden for them to provide for those accommodations. And the courts have to date not found that to be true, right? That there are substantial resources at most higher education institutions, at least substantial enough to provide for those accommodations. It doesn't stop the universities, though, sometimes from attempting to avoid spending on that. But ultimately, right, we hope that they do the right thing with that. Was there another question, Charlie?
Yeah, last question, John. We've got about 5 minutes left.
Okay.
Is somebody asked for the AHEAD site, AHEAD in caps?
I believe it's ahead.org. So ahead.org should be where you go to for that. I believe they have a lot of material that's on the public facing side, and then members can sign in. So we have an institutional membership here at the University of Dayton and get access to additional resources, discussion boards, things like that. But there should be a number of publicly available resources on ahead.org. So last thing here that I just want to go through quickly is to give a couple of just practical examples, right? So University of Dayton, we have about 12,000 students all told between our undergrad, grad, and law programs. At last count, we had 1,165 students. I checked this a couple of days ago, who have some form of accommodations through us, right? So that's almost 10%, which is, fairly good if you think about kind of the national, education population and where students are with that. We know there's probably more out there who have yet to seek accommodations but do have eligible disabilities. The Office of Learning Resources where I work is our Disability Services Office, and I employ 3 access coordinators. Those are our professionals. They each have about 400 students on their caseload, so it's quite a bit. We stay very busy all year round. Here's just a couple of our most common accommodations, just again to provide some kind of practical examples. Our testing accommodations are mostly extra time. Time and a half is standard. So if you think about a 60-minute class, the student would get 90 minutes. So half, right? 30 minutes of the full 60 added on top. That's time and a half, 90 minutes to do the test. Also a distraction reduced testing environment. We have a testing center here where students can go and take it in a quiet private room. Many of our in-class accommodations would be audio recordings of lectures, as well as getting copies of notes and PowerPoints from class. I mentioned we have things outside the classroom, right? So we have our housing and dining accommodations. You can see here, right, single rooms, private and semi-private bathrooms, meal plan exemptions or special meal plans that may be needed depending on allergies and different things. And then transportation and parking issues, right? Parking passes or exemptions from parking policies. University of Dayton doesn't allow freshman students to have cars on campus, but maybe the student's disability would mean they should, so that would they'd need an exemption from that policy, as well as medical transportation around campus. And then finally, we have our assistive technology. So these are a number of softwares that we provide for students free of charge. To get alternative format textbooks. They can use Dragon Naturally Speaking, which is a publicly available, although for a fee, text-to-speech software. Glean is our note-taking software where they record and get copies of notes from class. And then Read and Write, which is a text-to-speech where it reads that text out loud to the student. And then finally, we do a lot with emotional support animals, students who need an actual physical note taker in the class, maybe they've broken a wrist or something like that, and adaptive furniture, both bariatric, larger furniture, as well as things for students who might need to stand up in the middle of class and have a raised table, whereas all the desks are typically seated desks in the classroom. And with that, I think I have taken us right to the end. So are there any more questions, Charlie, that have come through?
John, thanks very much. There are no questions, but just
Great.
one little bit of input here. When our son attended Georgetown University, he typed his notes on a computer. His handwriting's even worse than mine, but he actually worked with the Office of Students for Disabilities and made his notes available to classmates who may have needed notes. I don't know whether you do something of that sort.
We do, yeah. If a student in a class has a note taker, we can make that available for other students.
I'd like to thank you for giving up your time and expertise. You did a wonderful job of explaining how disability law, very broadly stated, and accommodations work on campuses, using UD as an exemplar, but again, reflecting the general status of what goes on in higher education. We do greatly appreciate your time. Does anybody have any last questions before we let John go? If there are none, we're on a lunch break until 12:45, and at that point, my dear friend and colleague, Alan Osborne in Massachusetts, will be joining us to speak about the law of special education. And I think you'll look forward to and enjoy very much hearing what Alan has to say. So enjoy your lunch, and we'll see you back in about an hour and 15 minutes. Thanks for watching in, everybody. We'll see you shortly. Enjoy lunch. If you see my picture pop back up, don't be frightened. It means I'm going to raise a question. I'll monitor the chat box to see if people have questions from the audience. Okay. You have until about 2 o'clock, and then Jillian Bradshaw will come right in right after you. Thanks very much. We look forward to hearing from you.
And let me share my screen here, get my PowerPoint up. Okay, can everybody see the PowerPoint? Is that visible to everyone? Okay, in terms of questions, I'm happy to take questions during the presentation or at the end as well. I'm planning on speaking maybe 40-45 minutes, so we've got plenty of time for people to interrupt, and certainly plenty of time, I think, at the end as well. Hey, first of all, I'd just like to say what a pleasure it is to be here and addressing this very important topic. The topic of the symposium today is Rowley at 40. Coincidentally, the year 2022 also happens to be the 45th anniversary of the implementation of the federal special education law. And it's the 5th anniversary of the Andrew F. decision that Amy referred to a little bit this morning, and I'll be talking about a little bit more. So, now, for some reason, my screen is not advancing here. There. Just in the way of background, what is today known as the Individuals with Disabilities Education Act, or as Amy said this morning, we sometimes refer to it as the IDEA or the IDEA. That was originally passed by Congress and signed into law by President Ford in 1975. At that time, it was known as the Education for All Handicapped Children Act. And the act guaranteed a free, appropriate public education for all students with disabilities in the least restrictive environment. And that act forever changed how public schools in the US operated. Prior to implementation of the EHCA, or IDEA as we know it today, most school districts entirely excluded students who were difficult to educate. And those who were not as difficult to educate often were just passed on from grade to grade. And if they fell behind, they were pretty much ignored. No one ever thought of providing any services. A little bit prior to 1975, there were a few states, my own state of Massachusetts being one of them, that passed state laws that were fairly similar to the IDEA. When I started my teaching career in 1974, we were in the first year of the Massachusetts law. Now, the law also gives us a little definition of students with disabilities. They're defined as those who have at least one identified disability and require special education and related services as a result of those disabilities. The law does require that states provide children with disabilities their free, appropriate public education if they are between the ages of 3 and 21. There are a couple of exceptions there, but for the most part, any children with disabilities between the age of 3 and 21 are entitled to a free, appropriate public education. The definition gets a little circular because a child could have a disability and does not require special education, and that child isn't necessarily entitled to services under the IDEA, but could be entitled to services under the ADA or Section 504. Now, at the very heart of the IDEA is the development of individualized education programs for students with disabilities. And basically that is formulated by a group that I'll refer to as an IEP team. Various states have various names for that group, but the easiest title, I think, is a generic title is the IEP team. And that's a group of educators, specialists, and most importantly, the parents of the student with disabilities. Now, how does the IDEA define a free, appropriate public education? Well, unfortunately, it has never provided a real clear definition, except to state that it consists of special education and related services to meet the standards that are set out in the regulations. And I have those standards verbatim on this slide. Basically, it has to be provided at public expense and without charge to the parents. That's the free part, obviously. It has to meet any standards set by the state education agency. It must include an appropriate preschool, elementary school, or secondary school education. And it has to be provided in conformity with an individualized education program, or the IEP, obviously. And special education is further defined as specially designed instruction that conforms with the child's IEP. Again, we have kind of a circular definition here. But as I said, this definition provided very little guidance for school personnel. I remember back my own early days as a special educator, we often wrestled with the requirements of the law and saying, well, what do we have to provide? What are we required to do here? Now, over the years, many courts stepped into the fray, and they also wrestled with the definition as we did and tried to figure out what it meant. From the very beginning, courts held that appropriate meant more than simple access. But they did state pretty clearly that it fell far short of requiring school districts to provide the best that money could provide. In fact, one court here in the state of Massachusetts made the statement that the law does not require that the student with disability shall receive the best possible education, but assures that the efforts to educate will be effective and that the education shall be adequate and appropriate. As you see, we kind of have a lot of semantics and don't always have a clear-cut definition of what all of this means. So many of the courts did hold that schools were required to individually tailor their instruction to meet each student's specific needs, rather than fit the child to the existing programs. In other words, that just because you had a program you could put a child into, that was not necessarily appropriate if it really didn't meet the child's individual needs. A lot of courts also decided that even the existence of a better program didn't render a given program inappropriate. And in essence, what that meant is that as long as an IEP met the law's minimal requirements, the courts would approve it, even if the school district had available and had the ability to provide a better program. Okay. And still, again, as I said, IEP teams were left with little guidance regarding what the law required along the continuum from simple access to best possible. And along the way, we did have two major Supreme Court decisions, which I've put them up with their citations up on the slide. Just one little explanation on Rowley. There's a parallel citation there for the Education Law Reporter. That's published by West Publishing, and it's a compilation of all court decisions that have been decided in education. Basically, it goes back to 1982. Now, I say all court decisions. Somehow they missed the Andrew F. decision, so I don't have an Ed Law Reporter citation for that. So against that backdrop, along comes Amy Rowley. And as you heard, I'm going to give a few facts of the case that the courts found important. Some of this might repeat a little bit of what Amy said this morning, but I think it's important for us to all have a solid understanding of what the background is. So I'm going to go through those. First of all, as you know, Amy was hearing impaired. She happened to have minimal residual hearing, but she was an excellent lip reader. Okay. Actually, I haven't advanced to the next slide here. Sorry about that. When Amy entered school, she was placed in a regular kindergarten class on a trial basis. Okay. Initially, the school board did provide her with the sign language interpreter, but at the end of the trial period, the interpreter reported that her services were not required. Amy mentioned that this morning, and little difference. Amy said the trial was for a month. The court documents say the trial was for 2 weeks. Regardless, it was a very short trial. And I think Amy gave us a pretty good explanation this morning as to why she really wasn't using the services of the sign language interpreter. And I found it interesting to note that none of that was mentioned in any of the court documents that I can recall. No. Now, at the end of the trial period, Amy's IEP team met and they determined that she would remain in kindergarten. They provided her with an FM hearing aid that would amplify the words spoken by her teacher and classmates. And they also provided some services, as Amy mentioned, speech therapy, and they provided a teacher for the hearing impaired to meet with her on an itinerant basis. Now, when she entered first grade, they developed a very similar IEP that called for regular class placement, the FM hearing aid, and specialized services, but the IEP did not include the sign language interpreter. Amy's parents basically agreed with the IEP except for the exclusion of the sign language interpreter, and they asked that it be added to her program. Now, the school board denied that request for the sign language interpreter, and at that point, Amy's parents filed a due process complaint. And the hearing officer ruled in favor of the school board, basically finding that the sign language interpreter was not needed because Amy was achieving educationally, academically, and socially without the interpreter. On appeal to the, actually the hearing decision was upheld by the state on appeal. At that time, New York's Commissioner of Education heard all appeals. That practice has since been outlawed by the courts because it's supposed to be an impartial hearing, and they felt that the commissioner is not impartial. So now New York has a tribunal, and they actually have a state review officer that hears all appeals. So a little bit different, but regardless, the result probably would have been the same anyways. But the hearing decision was upheld on appeal, and then it went to the trial court in New York. The trial court reversed, ruling in favor of Amy and her parents. And the court basically found that although Amy performed better than average, she comprehended much less of what went on in the classroom than she would have if she were not hearing impaired. In fact, her parents presented evidence at trial that without the sign language interpreter, Amy actually comprehended about 59% of what went on in the classroom. With the sign language interpreter, she was estimated that she would have comprehended closer to 100%. So, and what the court basically said is that the school's IEP did not provide her with an opportunity to achieve her full potential commensurate with that of her peers. In essence, the court established a standard that said an appropriate education is one that would allow a student with disabilities to achieve his or her full potential to the same degree that the school district allowed students who were not disabled to reach their full potential. And a very brief, extremely brief actually, decision the Second Circuit affirmed. Interestingly, the Second Circuit also made note of the fact that its decision was limited to the facts of the case and really should not be applied to facts that were very different than those that we saw in Amy's situation. So this brought us to the Supreme Court decision. Okay, in a split decision, 6-3, the Supreme Court reversed the Second Circuit, in essence, going back to ruling in favor of the school district. Okay. And what the court ruled, in essence, is that the lower courts erred by requiring a level of services that would maximize the child's potential commensurate with the opportunity provided to her classmates. So it really struck down the standard that had been set by the trial court. So the Supreme Court, in essence, created what is now known as the Rowley standard. And that standard states that to be appropriate, an IEP and the educational program for a student with disabilities must be formulated in accordance with the law's requirements and must be reasonably calculated to result in educational benefit. And in applying this standard, the court held that the school board was not required to provide the sign language interpreter. And their reasoning was that Amy was performing better than average and was receiving personalized instruction that was reasonably calculated to meet her educational needs. And Justice Blackmun did file a concurring opinion. He basically agreed in the result, but he felt that the question was whether Amy's program as a whole allowed her the opportunity to participate in the classroom in a manner that was substantially equal to her classmates. And he was satisfied that this standard had been met, so he joined the majority. Justice White, on the other hand, dissented. And he stated, and I'll read his exact quote because I think it's important, is he stated that providing a teacher with a loud voice would not meet the student's needs and would not satisfy the act. I think he's kind of referencing the FM hearing aid that Amy had been provided, which in essence amplified what was being said by her teacher and classmates. So in his opinion, he felt that the lower courts got it right. And he thought that the standard should be that the child with disabilities be given an equal opportunity to learn if possible. And he noted that without the sign language interpreter, Amy comprehended approximately half of what her classmates understood. And in his opinion, that simply was hardly an equal opportunity to learn. Now, at this point, I'll just stop. And are there any questions at all, Charlie?
I'm having trouble with the tech. No, so far so good. I'll let you
No.
know if there are.
Okay, no question. Right? If anyone has any, if you would like to raise them now, I'd be happy to, to handle any. Let me get the screen back up again.
I think so. Thanks.
Yeah. As could be expected, we had a flurry of court activity after the Supreme Court's pronouncement. And that their decision has often been criticized by advocates for students with disabilities who have claimed that it set a precedent for providing only a basic floor of opportunity for students with disabilities rather than a level of services that would provide an equal opportunity to learn. And we saw that in some of the early court cases, particularly the first ones immediately post Rowley. And before I get into that, I also would just like to make note of the fact that since the Rowley decision, Congress has amended the IDEA 5 times, and they haven't changed the standard at all or even made any comment on the Rowley decision. So I think that's kind of an indication that Congress anyways perhaps felt that the court got it right when they made that decision. But the early courts basically ruled that IEPs would meet the Supreme Court's criteria as long as they offered some educational benefit, even if that benefit was minimal. Now, in essence, the courts were approving programs that gave students with disabilities access to educational programs, even if the benefits they derived from the services they were receiving were very trivial. Now, again, they interpreted some educational benefit as being any benefit at all. Now, one court, even went so far as to state that it would not interfere where a school district was providing an education that was of some benefit and was using a minimally acceptable approach. I'm kind of ashamed to say that that was a Massachusetts case. Later courts, however, posited that the IDEA required IEPs to provide something more than minimal or trivial. These courts did not necessarily require an IEP that was designed to provide optimal or ideal educational benefits, but they clearly stated that the educational benefit needed to be more than trivial advancement. In struggling to even define the term meaningful benefit, courts use terms such as likely to produce progress or measurable and adequate gains. Let me just give a few examples of what some of those courts said. One decision, Hall v. Vance County, the Fourth Circuit, stated that minimal progress made by a student was insufficient in view of that student's overall intellectual potential. The First Circuit stated the IDA does not require optimal benefit, but does require an IEP designed to confer a meaningful educational benefit. The Second Circuit stated that an IEP should open the door of public education in a meaningful way. And then the 11th Circuit basically stated that an appropriate education is one where a student makes measurable and adequate gains. Now, again, we're seeing a lot of semantics here, and it's what does all of this mean? What exactly is meaningful? And I think once again, we just have a term that doesn't have a precise definition. But against that backdrop, the Third and the Sixth Circuits, I think arguably established a heightened standard in several rulings, particularly the Third Circuit had several rulings where they stated that trivial educational benefit was not enough. Meaningful educational benefit required significant learning. So we're getting a little closer here. And the Sixth Circuit went so far as to state that judges must gauge the benefits in relation to students' potential and not set low expectations for students with disabilities. And these decisions basically set the stage for the next Supreme Court decision. And that was the Andrew F. decision. Okay. One of the problems that I see with the Rowley decision is that because it involved Amy, who was a child who was educated predominantly in the mainstream, the decision focused on what has to happen to children who are educated predominantly in the mainstream and didn't directly address the situation of those who are educated in other situations such as special education classes. And in the Andrew F. case, the child involved here had been diagnosed with having autism and attention deficit hyperactivity disorder. And because of his disability, he had problems with cognitive functioning, language and reading skills, as well as social and adaptive abilities. Andrew attended a public school from preschool through the 4th grade. And during that time, he received special education and related services pursuant to an IEP. But during those years, his IEPs really didn't change that much from one year to the next. They had very similar goals and objectives, and the services he was offered pretty much stayed the same. But as he was about to enter the 5th grade, the school district developed a new IEP for the 5th grade years. And at this point, his parents had become very dissatisfied with his progress. They felt that his progress had essentially stalled and he wasn't moving forward. So they rejected the IEP, which in their view, pretty much just repeated previous IEPs that they felt had failed. So they then unilaterally enrolled him in a private school for children with autism, where reportedly he started to do much better. But after enrolling him in that school, the private school, his parents filed a due process complaint claiming that the school board had committed procedural errors in developing his IEP. And they also claimed that the IEP was substantively inadequate. And thus, between the procedural errors and the substantive inadequacy, they claimed he had been denied a free, appropriate public education. So an administrative law judge, after examining the facts, ruled that the proposed IEP did in fact offer a free, appropriate public education. But the federal trial court in Colorado upheld that order, and the 10th Circuit affirmed. Take a look at the 10th Circuit decision. That was the one that really had, I think, the most information in it. The 10th Circuit was satisfied that any of the procedural errors that the parents claimed the school board had committed, if in fact they were errors, did not hinder the parents from meaningful participation in the IEP process. And for that reason, the procedural errors did not deny an appropriate education. Now, in reviewing the IDA's requirements, the court looked back at his own precedent in previous cases, and it decided that in those cases, it had subscribed to Rowley's some educational benefits standard. And they very specifically declined to follow the Third Circuit's heightened meaningful educational benefit standard. So looking at the facts of the case under those standards, the 10th Circuit determined that the child had progressed under previous IEPs, and therefore his proposed IEP was reasonably calculated to confer educational benefit. Now, interestingly, the court did note in its decision that the goals and objectives of his IEPs had increased in difficulty, which indicated that he had made some progress. And the court also commented favorably that school personnel had worked collaboratively with the parents and had called in specialists when they felt specialists were needed. And this, of course, was appealed to the Supreme Court. And in a very rare, and I guess something that's going to be increasingly more rare, the Supreme Court issued a unanimous decision where they vacated and remanded the 10th Circuit's ruling. And the court started off by taking a look back at its Rowley decision. And in commenting on that decision, Chief Justice Roberts wrote the majority opinion. And in reflecting back on Rowley, Roberts explained that the court's previous ruling reflected the proposition that the IDEA cannot and does not promise any particular educational outcome.
Alan, can I stop you here with a second for the question for the audience? Because
Sure.
the only reason I'm stopping you here is I think it fits. You're on the question that somebody just raised. I wonder if you could say a little bit more as you continue about the deficiency of the Rowley standard, not only as the Supreme Court perceives it, but also in your experience as an educator and a researcher. Why was it so lacking? If you add that in your discussion, thanks.
Actually, that question does fit perfectly here. Where I see it was deficient is that the Supreme Court in Rowley did not take into consideration what Amy's potential was. Now, you all saw Amy this morning. She has gone on, been very successful in school. She's earned a doctorate, and today she's a professor. Now, I'm certainly not going to go and say that everybody who has a doctorate is absolutely brilliant, but she's been very successfully academically. She's been very successful in life. She is obviously a very intelligent person and one who had great potential right from the start. And that potential was never taken into consideration. What we'll see here from the Andrew F. decision is now the Supreme Court is clarifying that the child's potential does need to be taken into consideration. Now, I hope that answers the question. If not, I think as we go on a little bit, see a little more of what I mean by that. What the court did say is that even though the IDEA doesn't promise any particular outcome, an IEP must aim to enable the child to make progress because the purpose of an IEP is to establish a plan for pursuing academic and functional advancement. And Roberts went on to say that any standard not focused on student progress would do very little to remedy the stagnation that caused Congress to pass the IDEA in the first place back in 1975. Remember, as I said early before that, most students with disabilities receive no services whatsoever. I know when I was a student back in elementary and high school, which now of course is ancient history, I don't recall any special education classes. You know, I remember a few kids once in a while left the room for some speech therapy or some remedial reading, but certainly not the level of special ed we're offering today. Now, and I'm going to just read a quote because it's very important from the Andrew F. Court. Basically, the standard that they established, and I am quoting exactly here, is that the progress contemplated by the IEP must be appropriate in light of the child's circumstances. That should come as no surprise because a focus on the particular child is the core of the IDEA. So the court went on to say that the child's program must be appropriately ambitious in light of his or her circumstances. And they use that term, circumstances, very often throughout the decision. So they added that the IEP for a child who cannot reasonably progress through the regular classroom doesn't need to aim for grade level advancement. And still, however, it must be appropriately ambitious. So even if a child cannot advance from grade to grade, you know, remember back with Rowley, the court said that the program for a child in the mainstream should allow the child to receive passing marks and advance from grade to grade. Now the court is basically saying that for those children who cannot reasonably advance from grade to grade, that doesn't have to be the objective, but still the objectives have to be ambitious. So the goals may differ, but every child should have the chance to meet challenging objectives. So now, turning to the lower court decisions in NDUF, Roberts stated clearly that an IEP that offered little more than minimal progress, as Andrew's IEPs had, was not sufficient. So to summarize his decision, or the court's decision, Robert clarified that the IDEA requires an educational program reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. So they're basically here clarifying what they said in Rowley, which is, you know, some educational benefit, but that benefit must take into consideration the child's potential. And again, the court repeated that the adequacy of an IEP turns on the unique circumstances of the child for whom it was developed. It must be individualized. And you know, the words challenging and ambitious come up quite often in the court's opinion. And I think that's the lesson we should be getting from Andrew, is that regardless of the child's disabilities, regardless of their abilities, their potential, whatever, their IEP has to be challenging and has to be ambitious. So after this decision, the 10th Circuit, this was remanded back to the 10th Circuit, but the 10th Circuit kicked it back to the trial court for further proceedings consistent with the Supreme Court's opinion. And interestingly, this time around, the trial court reversed the administrative law judge's decision and ruled that the IEP was not reasonably calculated to enable the child to make progress in light of his unique circumstances. The court went on to say, now this is the court that said previously said that the IEP was adequate, now found that the IEP continued a pattern of unambitious goals and objectives and was no more than a continuation of previous IEPs that had resulted in minimal academic and functional progress. So what's the difference here? Well, the basic difference is that previously the trial court felt that the standard was some educational benefit, regardless of how minimal or trivial. And now they have instructions from the Supreme Court that is basically saying the goals and objectives have to be ambitious and challenging. So What's happened since then? Well, first of all, NUF has not really been a game changer. It did not create a new higher standard. What it did do, however, is it claimed that some educational benefit meant more than minimal benefit. It also made it very clear that the benefit to be received by the student with disabilities must be commensurate with their potential, but didn't necessarily have to be commensurate with those offered to their peers who do not have disabilities. So we don't even have this yet, the standard that had been created by the lower courts in Rowley. They also, the court since Andrew have ruled that IEPs do not have to be ideal or the best possible program that money could buy. And that's not something that would be unexpected, because we probably don't provide an ideal or best possible education for any students. No matter what we provide, we can always probably do better. But the courts have also, many of the cases that have come up since Andrew have involved students with more significant disabilities. And the courts have ruled that slow progress for some students does not equate to a denial of an appropriate education. They recognize the fact that not all children will make the same amount of progress. For some children, slow progress is what's to be expected. Even so, the progress has to be meaningful and has to be appropriate in light of the child's circumstances. So for the most part, if the courts are presented with an IEP that includes ambitious goals, allows students to make appropriate progress, they are ruling that those IEPs do meet the IDEA's requirements, even if more could be done. And they also do recognize very much that grade level advancement is not a reasonable expectation for all students. Even some students who are educated mostly in the mainstream. And that's pretty much a recognition that many students today, unlike when the IDEA first was implemented, are educated more in the mainstream, and they're given inclusive educational programs where many services are delivered in the general education environment. One court even went so far as to say that you cannot measure progress by state administered tests, because they're not necessarily appropriate for all students in terms of measuring what the IEP has achieved. And again, what the courts have reiterated is what the Supreme Court emphasized, and that's that IEPs must be challenging for all students and may not set low expectations. So just a few thoughts in conclusion. First of all, it's not really very realistic for us to expect a one-size-fits-all definition of a free, appropriate public education that will fit all students, given the fact that every student is unique. We do have approximately 7.2 million students receiving special education in the United States today. And given the fact that the I in IDEA is individuals, the I in IEP is individualized. In essence, what we could possibly have is 7.2 million definitions of what is appropriate, because what's appropriate for one student isn't necessarily appropriate for another student, even if the two students appear very similar. They each are unique in some ways. But what we do know is that IEPs must be ambitious, but they should be realistic. Each student's situation needs to be taken into consideration. And that means taking into consideration their abilities, their potential, and any limitations they might have. And what I kind of come back to at the end here is that is a quotation that comes from the Sixth Circuit. It's an old quotation, goes back to 1993. This quote has often been cited by other courts. And basically what the court stated is that the act requires that schools provide the educational equivalent of a serviceable Chevrolet and are not required to provide a Cadillac. And what I would like to add to that little analogy is that that Chevy has to be adequate. It must be maintained so that it'll allow its passengers to reach their final destination. And I'm quite sure that the Chevy Bel Air that I drove in high school would not meet the Supreme Court's requirements. Thank you, and I'm ready for some questions if you have any.
Alan, as we wait for questions, as you and I spoke offline a little bit earlier this morning, following up with Amy Rowley's conversation, if she could wave a magic wand or become a member of Congress or what have you, what changes would you implement in the IDA? Maybe not necessarily to bring it up to the level of a Cadillac, but certainly to do a better job of providing services for kids.
Well, first of all, let me make a comment on the court decisions in general. The purpose of the courts, of course, is to interpret the law, not to make law. And in that respect, I do think the courts have gotten it right. They're interpreting the law the way it's written and the way it was perhaps intended. But I think the standard that should be written into the law is the standard that was set by the lower courts in Rowley. And that's that students with disabilities should be given the opportunity to meet their potential to the same degree as students who do not have disabilities are given the opportunity to meet their potential. And granted, that's also probably a standard that's difficult to measure. But I think it brings us closer to what should be an equal educational opportunity for students with disabilities. So what I'm actually saying is someone who spent 35 years in the public schools is that the public schools should be required to do more than they're required to do right now.
But can you put that into words? Could you describe it in some way? I mean, as you properly describe, it's an amorphous standard. Is there any language that might help us to zero in just a little bit more?
I think it's, no matter what we do, we're going to be talking semantics. And I think it's hard to escape that, but I would go right back to the trial court in New York and use the language that they used and just state that the opportunity must be commensurate with the opportunity provided to students who do not have disabilities. I think that's probably the best we're going to be able to get. As I said earlier, there's so many different categories of disabilities, so many types of disabilities, and even within those categories, students are so unique. A good example is students with autism. Some of them function very, very well in regular education classes with some support services. There are others who really cannot function in that same kind of an environment because their autism is much more severe. So you can't prescribe the same type of program for all students in a category. And even two students, you'd have two identical twins, for example, who appear to have the same disability, and their needs may be a little bit different.
Let's see if anybody else wants to join, and I have some other questions I think would advance. Here came one in now, just let me read it. How should the court handle a school or school officials who make conscious decisions to continue, I'm adding to a little bit, to provide only the minimum standard and hope parents will get cut out, will get worn out and quit? And put another way, what do you do with school systems that try to wait out the parents and string it out? Any thoughts? Well, I'm sure you have some thoughts. And here's another one. Let me read you two, and you can keep them in your back of your mind. If every child is unique and every student's plan should be unique, how is school supposed to really measure progress? Won't that always be subjective? I'll leave those to you. I can repeat them if you like.
Okay, I'll answer the second question first. And yes, I agree. It can be subjective. And, you're trying to measure the progress of students with disabilities. As I mentioned earlier, one court went so far as to say that state level tests that are given, almost universally now, as a result of No Child Left Behind and the standards movement, aren't really appropriate for a lot of students with disabilities. Often the type of testing that we have to do with them is much more subjective. And someday maybe we'll advance the science of education to the point where we have better measurement devices. But until then, there is going to be a lot of subjectivity in it. In terms of what the courts can do for school districts that can continually do the minimal, continually violate the law, I'm not going to mention them, but there are some school districts that we happen to see come up quite often in litigation, and generally speaking, they lose. These are districts that, for whatever reason, repeatedly are not doing what they ought to be doing. They're getting caught at it, and they continue to do it. I've seen some courts get very frustrated with that situation. I've seen some actually go so far as to threaten school officials with contempt of court if they, don't get their act together a little bit. There really isn't much of a sanction against those school districts except the withholding of federal funds. The problem with withholding federal funds is now the school district has less money to do what they're supposed to do, and it's only going to make things worse. So what is the answer there? I think the answer is that parents and advocates for students with disabilities do have to be diligent. One problem, Charlie and I have both discussed this. If parents sue a school district and the parents win, the parents can recover their legal expenses, with one exception. They cannot recover the expenses of any experts that they hire to be expert witnesses at the due process hearing or at court. They have to bear the burden of those expenses themselves. They can be considerable. For a parent to come up against a school district that has experts on staff that can be witnesses at the hearing and testify at the hearing, it can be very considerable. And if the parents win, partly because of hiring those experts, they can't recover the cost of those experts. And I think that's something else that needs to be adjusted in the law. Charlie and I have actually written about that a little bit. But Congress doesn't listen to us, Charlie. What can I say?
They don't listen to too many.
No, they don't.
Here's just two other questions. First one to begin by saying, this may be an unfair question, but I'm not sure that is. I think it's fair game. If progress is largely subjective, then where is the space for parents really to say or to prove that the child is not getting what they should have gotten from the school? I think part of the answer is going to come out in due process, but second one is kind of related. So you have to be able to have experts to say the child isn't getting what they need. Okay. I'll let you respond, Alan.
The expert witnesses are very important. And anyone that's been involved in the due process hearing knows that they can go on for days. And the transcripts and the opinions that come out of that can take up pages upon pages upon pages. And that's where most of the fact finding takes place. The trial court doesn't hear the case all over again, unless for some reason they feel that the hearing officer really got it wrong. The trial court usually is applying principles of law more than they are trying to sift through the facts of the case. They generally accept what the hearing officer found as the finder of facts. It is subjective. I won't deny that. But even being subjective, you can come up with some criteria. For example, in special education, when the IEP is written, it has goals and objectives. You have to provide progress reports that are issued the same way report cards are issued. If report cards come out 4 times a year, progress reports have to come out 4 times a year. And those progress reports have to basically report specifically on the objectives of the IEP. Are they being achieved or are they not being achieved? If they are being achieved, then at some point they have to be adjusted and upgraded and made a little more ambitious. If they're not being achieved, then the IEP needs to be modified so that they can be achieved. And that's the kind of stuff that does come out in a due process hearing. But again, it does require expert witnesses sometimes on the part of the parents to be able to prove that an IEP isn't working.
Now, and a question I've heard that follows up on that, and I'm sure you've heard it as well, is that some critics of the IDEA suggest that the IDEA is tilted a little bit in favor of parents, that parents can bring a due process hearing over almost anything, even if it's questionably of meritorious value. But school boards don't often bring claims. How might you level the playing field? How would you get the board, conversely, to deal with parents who don't come to IEP meetings? What can, should, might educators do? When you were a principal, what did you do when parents didn't show up for IEP meetings, who didn't respond to calls? And what thoughts could you offer on that? Particularly keeping in mind that we have a number of attorneys. How would you advise a board attorney to deal with that situation?
Yeah, I'm actually gonna make a confession here. When I was principal, the elementary school I was principal of was in a very low income district. Approximately 96% of our students receive not only free or reduced lunch, but out and out free lunch. The school I was principal of, for the most part, served the federal housing project. It could be difficult to get parents to come in. One reason it could be difficult to get them to come in is that they themselves had not been successful in school. And they really didn't want a lot to do with the school. Now, in Massachusetts, what the law requires is that we give the parents 10 days notice in writing of an IEP meeting. So we have to invite them at least 10 days before the IEP meeting. We discovered pretty quickly that if we invited them 11 days before the meeting, they weren't going to come. If we violated the law and invited them 2 days before the meeting, we got them in. And we actually ended up with about 98% attendance. Sometimes we had to reschedule the meeting a couple of times and do some urging to get the parents in. But we were able to, by being very diligent about it, working at it. And in doing so, it helped our relationship with the parents. Now, one other thing that helped as time went on, I was in that school for 25 years. I started off as a teacher, ended up as the principal. By the time I was principal, many of the parents had actually been my students. I hate to admit that, but they were. And I was still their teacher, and they did what I told them to do. So if I told them to come in for a meeting, they came in for a meeting. But we did bend over backwards to get parents to come in. And I'll give one example. We were notified one time by the mother of one of the students that the father wanted to come to the meeting. The problem was that the father was a guest of the state in one of our houses of correction. So we brought the meeting to him. We held a meeting in the prison. And his motivation was pretty good. He didn't want his kid to end up where he was. And by the way, his kid didn't end up where he was. So it doesn't take a lot of effort to get the parents in. It does take effort in some cases, but you can do it. But I think, to address a totally different question that you didn't ask, you started off by saying that some people feel that, the IDEA might sort of favor the parents, and the parents can sometimes, file frivolous lawsuits and that sort of thing. And there have been cases where there have been some frivolous lawsuits. And in one of the more recent amendments to the IDEA, they expanded the attorney fees provision so that actually, interestingly, the attorney of the parent's attorney can actually be made to pay attorney fees to the school district if the school district wins and they can prove that the case truly was frivolous, or that the attorney continued the litigation after it was very clear that the case was frivolous. What I have to say is courts are extremely reluctant to do that. But that sanction is there. Some courts have actually issued sanctions against attorneys in cases where they felt that they, continued a case that was frivolous, but those sanctions don't necessarily amount to having to pay the school district's legal fees. I think, the danger of a frivolous lawsuit is so small that it's worth the chance. It's better that parents be encouraged to file lawsuits when necessary.
So I think the downside of that is, how do you wind up denying a good claim? Or if you're an attorney, why would you not take a case that appears to have merit, particularly if it's a new issue?
Good question. I'm not really sure I have an answer to that. And on the flip side of it, I also have to look at the amount of money that's spent on litigation. And I have to stop and think, wouldn't it be better for that money to be spent on educating kids? And, I know some people have very facetiously referred to the IDEA as the Attorney's Full Employment Act. I certainly would never do that. But I don't know. I've seen attorney fee cases, as says Charlie, I'm sure, where the reimbursement school districts have to pay to parents because the school district was wrong goes into the hundreds of thousands of dollars. That would hire a few teachers. It would provide a lot of services to students. And the bottom line is somehow we all have to work together to get it right.
Good point. Just the other day, I'm teaching a course on special ed law in the law school, and I made the point by analogy. It's broadly almost like tort law. When parents recover those attorney fees, they're really just being put back in the position they should have been in had the school board done the right thing to begin with. So they're not really recovering anything. It's really honoring the free of the appropriate public education, because they shouldn't have to pay to get what their kids are entitled to from the outset.
Exactly.
One last question, then maybe we'll have Jillian come in. But a question I like to ask online, and I think it drives students crazy sometimes. If you were to give the IDEA a letter grade from A to F, A to D, what letter grade might you give it for effectiveness?
I think I'd give it a C. Prior to the IDEA, what schools did for special ed students, I would have given them an F. Now they're getting services, they're getting some decent services. Some schools certainly deserve a B, perhaps even an A-, but there is more that we could do. And, we're seeing good results. There's no question about it. I don't want to take anything away from what the IDEA has accomplished, but I feel that we're still coming short of providing students with disabilities with an equal educational opportunity. A lot of students who receive special ed services end up doing extremely well. A lot of that is due to their own effort. A lot of it is due to the effort of their parents. But those who do best, it's because of their own effort, their parents' effort, and the efforts of the school district. And as I said, we've got to work together. The good thing is Charlie mentioned, I've been writing the chapter on individuals with disabilities, or students with disabilities, for the Yearbook of Education Law now for 30 years. But when Charlie said that, it made me realize how old I am. But in that time,
We are.
can't get away from it. We're getting old. But in that time period, I've seen the litigation increase, and now I'm starting to see it decrease a little bit. That chapter is getting a little thinner each year. The last couple of years, it's been a little thinner than the years previous to that. And I'm not quite sure why, but that's a good thing. I'd be very happy when we reach the day when that chapter is no longer needed.
Fair enough. And one last comment, particularly for the attorneys out there. I know Jillian's going to come in, and Jillian, who's speaking next, does a great deal with policy advisement. Alan and I belong to a school of thought through the Education Law Association and other organizations. We believe in preventative school law, not so much to win the lawsuit, but prevent the lawsuit from happening by getting resolution at the school level. Any final thoughts on that? Then if not, I'll thank you, and then we'll bring Jillian in.
I think a lot comes down to training. I think, and I don't just mean training in methods and that sort of thing, but school districts certainly could do a lot more in training their staff on what the law requires and what the staff should be doing. If too often we train the administrators in the legal issues, we don't train the teachers. I don't know too many colleges that offer a course in special education law for teachers. But many times mistakes are made because people don't understand the law or don't even know what the law requires. If we do a better job of training them in the law itself, and granted, I'm biased in that regard, that's what I write about. But if we did a better job training them, I think we could reduce a lot of lawsuits.
Well, Alan, thanks very much for your insightful comments as always. I hope you'll be able to stick around. We're going to try to have a closing panel at about 3:45 or at 3:30 rather, sorry, after the international panel at 2:45. But you gave us a lot to think about. I appreciate your thoughts and hope you stick around. One last time, are there any questions on Alan before we welcome Julian Bradshaw? And Alan, you, as always, did a wonderful job. Thank you. Hopefully the Yankees beat the Red Sox again tonight.
We'll see about that.
Alan, thanks. Hope you stick around. And now I'll introduce Julian Bradshaw. Jillian, if you turn your camera on, there you go. It's my pleasure again, personally and professionally, to introduce Jillian. She may not want this known, but Jillian made the mistake of taking ed law with me a number of years ago in the law school. She is an attorney with the firm in Dayton, which is not just in Dayton, Porter Wright, Morris and Arthur. She concentrates in education law, collective bargaining. She works on administrative proceedings. As I mentioned, she does policy advisement, employment issues, and labor relations. Prior to joining Porter Wright, she was general counsel for the city of Dayton Public Schools, where she again engaged in extensive collective bargaining activities, worked with the board, superintendent, treasurer, human resources department on lots of different issues, dealt with policy matters. She came to education law because of her background as a teacher in her native Florida. Jillian is also award-winning. She was 2022, recipient of the Dayton Business Journal's 40 Under 40 Award. She will be an upcoming speaker in Dayton at the TEDx Dayton event. And to plug the Education Law Association, she will again join me and some friends on a general session at the Education Law Association, talking about our ongoing interest in areas of religion and public education. One of our speakers will be Richard Katsky, who argued the case in Kennedy versus Bremerton. He argued it on behalf of the school board. But Jillian is not going to talk about religion today. For the next 35 or so minutes, Jillian will talk about very practical issues for attorneys who work with special education. Julian, as always, thank you for joining us, and we look forward to hearing your comments. I am going to mute and go off screen. If you see me pop up, don't be too frightened. It means there's a question. So Jillian, look forward to it. Thanks.
Oh, thank you, Charlie. Your introductions are always very flattering. I certainly appreciate it.
Very
and,
true. Not flattering.
to the attendees in the room, you're not going to be able to have really cool New York and Boston accents. You have to listen to like Midwest mom for a while. So little change of pace in that regard. But I'm going to talk to you a little bit about some of my practice experience, expand on what Dr. Rowley was talking about in her experience, and certainly what Dr. Osborne has just spoken about in his experience, and put that all through sort of a different lens, as the lawyer in the room. And so currently I'm licensed to practice in Ohio and Pennsylvania. And my experience related to special education issues really was the most robust during my time as general counsel for the Dayton Public School District. As you can imagine, Dayton Public is a large urban public education system in Ohio. It's one of the 8 urban districts in Ohio. And I was so thrilled to hear Dr. Osborne talk about his experience as an educational leader in urban education, mostly dealing with students, with challenges related to their socioeconomics, usually very difficult family backgrounds, often victims of trauma, multiple traumas. All of that is very much connected to what we're talking about today. And we almost can't even talk about the law of special education without talking about the children themselves and their experiences, and why it's so important that the laws are written the way that they are. When they say the word individualized, that is for a purpose. And when put into practice appropriately, generally does the job. So, but I'm going to start a little bit about how lawyers even end up in the conversation when it comes to special education. And Dr. Osborne's comment about training teachers, if I had my camera on, I was doing this, because if I could ask for anything forever and ever into eternity of public school districts, or any other school for that matter, it would be to be very intentional about educating not only your administrators and not only your special education directors, but any teacher in the district should have a working knowledge of these legal concepts. They should have a working knowledge about, FAPE, IDEA, the ADA. It's becoming such an essential function of being an educator in general, that I think one of the most valuable things that districts can do is to seek out an appropriate legal professional to provide that type of training. And 1 hour is not going to cut it, right? It's going to, be rather lengthy, and the benefit that will result from that is tenfold, because as Charlie said, the best law is the type of law that prevents the lawsuit. And I think training people to understand what the law is and how to, work within its confines is very, very valuable. So in the times that I do get to train special educators, whether it's intervention specialists or directors of special education departments or otherwise, I do spend a little time talking about the law, and I spend just as much time talking about communication. In my experience, in the times that I've had to attend an IEP meeting or attend a due process hearing, something along the way, usually very early on, a relationship becomes fractured somehow, whether that is with the student and the educators that are attempting to work with the student. More often is with the student's parent or guardian and the relationship that exists between that parent or guardian and the school officials. At some point along the way in a child's special education journey, if those relationships become fractured, and if the communication skills are not in place to work through those type of conflicts and arrive at resolution, you can almost guarantee that these issues are going to become litigious. And you know, I was really happy to hear Dr. Osborne talk about you know, the new publications of you know, whose idea is this? The handbook related to the IDEA is now including these disclosures about how attorneys' fees are recouped. There have been very, very few circumstances where I've seen families sort of take advantage of the law and attempt to, you know, file or claim something that would be considered frivolous. And mind you, that's a very high bar. For a case to be considered frivolous, the facts have to be very, very blatant generally. So during these trainings, I spend a lot of time, like I said, talking about the law, but more so talking about communication styles, and even resources that are required to make sure that that communication takes place effectively. There are often IEP meetings where the parent or guardian of the child doesn't speak the language. There have been plenty of times where the parent or guardian of the child cannot read. And so the district has to be equipped with these services to even ensure that the appropriate communication is taking place so that the appropriate consents can be gained to then provide the services to the child moving forward. And, you know, putting my district hat back on for a short time, that is becoming increasingly more challenging for school districts. And to be clear, I absolutely agree that the law related to special education needs to be individualized, and it needs to be a student focused, not funding focused. But I will tell you, just as a practical matter, districts are really struggling right now, struggling to find educators at all, struggling to find educators that are willing to gain those additional licenses to be considered intervention specialists and, you know enough to work with students with disabilities, and then finding appropriate resources for interpreter services, you know, certain types of disabilities, whether they, you know, auditory, visual, you know, multiple handicaps, medical impairments, things like that. Districts are having a really hard time. And so I've been involved in a case where a student, actually it was two students, had a disability that required a certain type of accommodation, and the district for a very long period of time couldn't find a person who was willing to come work for the district to provide those services. So you've got a job posting that's, you know, out in space for, you know, a month, that turns into 2 months, then 6, then 8. And the district says, we can't find anyone to provide this service, can't find a vendor to provide this service. And so from a resource standpoint, I know districts are simply having a very hard time. Certainly doesn't excuse any of the legal obligations that are incumbent upon districts as it relates to providing services. But I know that because of those struggles, these types of conflicts are on the rise. We're seeing more disagreements between families and school districts who are looking for some specific accommodation, whose child needs a specific accommodation in order to have full access to their educational environment. And I think public school, and I don't think this is unique to Ohio. I think public schools around the country are just really struggling to get people in the door, even just to be educators in general. So that's note number one, at least that I've seen from a practical standpoint, and part of what I do in terms of trying to train folks who are in this business. The way, so I want to talk a little bit about the role of educators when it comes to maintaining legal compliance. And that, of course, presumes that those educators understand what's required to maintain legal compliance. So the training piece sort of has to be covered. And I think when teachers have a working understanding of the law, what's required of the law, what's required of them, in terms of, how often do these documents need to be updated? How often does the IEP team need to get back together? A big one comes in when we're talking about a student with a disability who is also struggling with some behavioral issues. There's a lot to know in how to handle that appropriately. And so the teacher's role in managing all of these things is a big one. Obviously that's no surprise. And again, I think the cornerstone for having that work well is making sure that those teachers have the relationship with the child, know what progress will look like for that child. And it is subjective, and I don't take much issue with that, simply because teaching as we know it now, though I think for years and years people in education have tried to quantify education in a way that makes everything visible via an objective measure. I think that's a very difficult thing to do, because so much of teaching and so much of education is actually an art that can't actually be quantified. The exercise that I give in thinking about that idea is, if you close your eyes and you think about the best teacher that you've ever had, or the favorite teacher that you've ever had, whether it's elementary school, high school, college, whatever, and you ask yourself, okay, so what was it about this educator that made him or her so special or so effective? How did I remember all of this information that he or she gave me, through this educational process? And it's kind of like the X factor. It's almost like you can't really define what makes an educator so effective. But at least in the comments that I've received in response to that question, it's been, well, we had a good relationship. That teacher really cared. That teacher asked me how I was every day, or knew if something was wrong, or took time out of their day to just check in and make sure I understood a concept. It's these sort of intangible things that are often attributed to highly effective educators. And it's those type of educators and the work that they do in building relationships and maintaining open lines of communication with students and with the families that mitigate all of these other issues, because that educator can come to the table to have a difficult discussion about, whether it's the student's progress, or whether it's a student's behavior as of late, or whether it's to address a behavior that might be manifesting as a result of the disability, as a result of something else. The relationship and the ability to communicate about those things effectively is the most valuable tool an educator can exercise, not only in being effective educators, but maintaining legal compliance. They're connected. And so a little bit about resources for schools and families. There are quite a bit of resources as it relates to information, as it relates to resources for districts, like tangible resources. If you're talking about money, that's sort of a separate conversation entirely. And I think we have to talk about the way public school systems are funded, really to sort of snapshot that issue, which we would be talking for days about that. But resources for districts, obviously districts, because they are these large organizations with much larger budgets than, most families. The resources, they've got legal resources available to them, obviously teams of people that are dedicated to these type of tasks, things like that. And when you're talking about families and some resources that may be available for families, there are far fewer resources to be able to know what the rights of students are in going into these type of conversations, to understand sort of the timing. Evaluation timelines sometimes can be very difficult for families to understand if the world of special education is new to them. And so, the publication that I referenced, and I think others did too, whose idea was this, or is this, something like that. The publication that the Ohio Department of Education puts out regarding the IDEA is a pretty decent snapshot of the law and the rights that are afforded to families under the law. And it's written in a way that's pretty accessible and pretty digestible. It doesn't include as much detail, I think, as one might prefer when, families start to ask questions about, well, what's the actual requirement of the school? If I ask for this thing, does the school have to provide it? What if the school psychologist says something that I disagree with? What if there's a test result that I disagree with? And so becoming familiar with that document, I think, is very important. And certainly for families of students with disabilities, being reasonably knowledgeable about your rights is key, because I think that then equips the family to advocate appropriately on behalf of the child. And I was so fascinated to hear Dr. Rowley's keynote this morning, because as Charlie mentioned, you read these cases, and I've probably read, I don't know how many versions of the Rowley case, annotated, all different versions, but she provided so much additional context that I thought, my gosh, I've read this case so many times, and now I have this sort of special insight as to this child's perception in this experience that took place over a number of years. And, even Dr. Osborne alluded to so much of what she said wasn't and wouldn't be reflected in the court documents. So how could we possibly know, some of these little details that shed what I found to be some fascinating light on the issue. So I was super intrigued and thrilled to hear that. But it's those type of details, I think, that are just required to properly analyze these type of situations under the law. And that it sort of leads me back to my previous point about these laws being written in a way that make it so that these education plans have to be individualized. It should be that way. Every child is different. Every disability is different. And the way that you work through those things in a way to ensure that that child's educational opportunities are appropriate requires this sort of bespoke process that looks different for every single child that goes through it. District officials and linear thinkers like lawyers sometimes are, kind of fuss at that because they might say there's so much gray area. There's no black or white answer. I would love to be able to say, here is the solution. We can plug this solution into this system and we're just going to keep churning and we'll be able to go about our day, because we have so many students that have disabilities. I've heard this before. It's wrong, but I've heard this before. District officials will say, well, I don't know when I'm going to be able to find the time to have these meetings and complete this paperwork and do all of these things, to which my response is, you've got to find it because the law requires it. And it's that time spent in building the relationship with the student, the family, understanding the facts of the case, and making sure that that student is educated appropriately. That time is worth it because the law is structured to make it that way. You've got to spend the time, you've got to get this unique plan in place, you've got to implement it, and it's all for the benefit of the student. So if there were any resources that I would wish for districts today, it would be more people who feel very mission driven or called to the profession of education, called to the profession of educating students with disabilities, getting more people in the room to advocate and care for the young people who are navigating this system, the families that are navigating this system. I always kind of thought, in hospitals, some of you may have heard of this type of arrangement. Sometimes hospitals actually employ what they call patient advocates who can assist a patient and their family through any sort of, whether it's communication barrier or systems barrier or something about the process that is confusing. The advocate can help them work through it. I always kind of thought, if there was someday when public school districts in Ohio said, wow, we have some money and I think we need some extra people, what should we do? That would be the greatest value add. That would be my first recommendation, is to hire internal student advocates to help students and families through these situations that can sometimes feel very overwhelming. Especially in urban education. There was a statistic from 2019, I think, that in the state of Ohio, 1 in 7 public education students was a student with a disability. I would speculate that number has gone up since then, even in the past 3 years. So it's certainly understandable that the time required to be dedicated to these type of issues is extensive, that the resources required to be dedicated are extensive, but they are appropriate. And so part of me hopes that Congress is going to call you up one day, Charlie and Alan, and say, hey, can you guys submit your recommendations for how we do this better? Because I think they'd be able to figure it out with that. But for now, at least here in Ohio, we're working through issues of funding and all sorts of other issues that systemically, I think, don't help alleviate the challenges ingrained in these type of issues in general. So, Charlie, we have any questions?
Jillian, thanks. I was going to raise a question for you at some point. Let me do it now. You hit on something that I've recommended often myself. When I taught at the University of Kentucky, I was involved at the Commonwealth level. And one of the things I recommended was what you just did. Why not create the position of some sort of parent ombud, particularly for parents of special ed kids, because the process is so complex. And to quote a line from one of my favorite movies, the Christmas Story, people around the table looked at me like I had lobsters crawling out of my ears. That went over like a lead balloon. But on Long Island, where I lived after we got married in Nassau County, many boards had that. So the question I was going to raise for you, and you anticipated part of it, I often say that if I had an hour to talk to a bunch of educators, the one topic I would talk about for an hour is negligence and inadequate supervision. That being said, 2 weeks from today, I'm doing a workshop for a Catholic school center, and my two topics are negligence and special ed. So my question to you with that long introduction, if you were speaking to a bunch of your attorney colleagues, what are the top 2 or 3 recommendations you would give to attorneys who work with school personnel, particularly in the area of special education? And then the flip side, to kind of quote Jen Psaki and circle back, what are the top 2 or 3 recommendations you give educators? You've already identified one, to help make the process a little bit easier. Because if you look at what used to be, whose IDEA is it in Ohio, it's written at a graduate school level. A lot of parents, even educated parents, are not going to get it. And I did see one question came in, so let me pull that one up. It's directed at you and Alan, but since he's not here, I think I know the answer. A question for Dr. Osborne and Attorney Bradshaw. Both agree teachers should receive more training in the law. Do they advocate training for the law for school board members? And with that, I will turn all that over to you and wait for some other questions, Julian. Thanks.
Sure. That's a great question. I apologize for chuckling a little bit because I think it's a timely question and a very important one. So at least from my understanding, to be a school board member in the K-12 public education space here in Ohio, there is quite a bit of training that's required to be in that seat. None of that training is related to special education. So if you're asking my opinion about whether board members should be trained on the law of special education, the answer is absolutely yes. Because at least in my experience, board members are approached very frequently, if it's in the grocery store or somebody calls their phone or at church or something, it's half the time going to be a parent saying, I've got this issue with my child and how can I handle it? Or how can you help me? And a good board member answer, because remember, board members are part of a governing body and they work at the policy level. So a good board member answer would be, let me put you in contact with my appropriate district leader, whether it's the special education director, so on and so forth. And that director should then make sure that that issue is facilitated to resolution. But I would love to see folks that are serving as board members become very knowledgeable in all the legal issues, at least general knowledge on all the legal issues that are implicated in the public education setting. And there are many. Charlie is talking about negligence and negligent supervision. It's a chapter in the book that Charlie has written and that we both teach from when it comes to the law of public education or the doctorate level course that we sometimes teach. Anytime, and Charlie, you probably get the same reaction, we're teaching these grad students about negligent supervision, everybody's eyes get this big. Because we read these cases and they think, oh no, surely I've done something like this in my time as an educator, at least a little bit, and so I have to say, well, it's important that you know the law behind these issues and how a court would analyze a certain set of facts that you perhaps would be presented with. And, I always feel comfortable trading word stories because I was a high school teacher. There were plenty of times where looking back now, I think, oh boy, I probably should have, done that differently or whatever. But I think that to the extent possible, folks in education, board members, leadership, teachers should have intentional training about the law. Because, we're not just making widgets, right? We're educating children. And that's important enough, I think, to make sure that the groundwork is laid to do it all right from the outset.
And are there any specific recommendations, though, what they should cover, how they should cover it? Beyond just the law itself, how about dealing with parents, dealing with due process hearings and the like, for the attorneys who very often don't get it, don't get the training, that is, don't get the education. The one course I teach in the law school is 1 hour elective. So there's only so much I could cover even in one hour. So, and we've got about 7 minutes left. So
Yeah, sure. I think, well, I think the first question was, what would I want to share with other attorneys about, this area and things to know. Gosh, it depends on what kind of attorney you're talking about, right? So I actually have had the pleasure of creating great relationships with attorneys who represent families for everybody in attendance. Generally, the work that I do is for districts. And so the best and most valuable relationships and resolutions that I've experienced are when, counsel for the district and counsel for the family both have a very sound understanding of the law and its details. And there's a lot to know. So there would be a lot of training required if you were a corporate transactional attorney trying to learn a little bit about special education. We'd have to spend some time together. But the best resolutions come from two practitioners who know the law well and who can help their client communicate effectively with each other. I mean, honestly, in all honesty, Charlie, in my experience, if I were to boil down all the special ed cases that I've ever dealt with into 10, 9.8 out of 10 cases are solved by taking the time to communicate thoroughly about what's going on and to help understanding sort of come through, to understand where the family is coming from, where the district is coming from, and to think creatively about appropriate solutions that are the best for the child. Sometimes folks, whether it's district or families, just need help talking about it the right way, in the constructive way. So.
sounds good. Well, you've got a great deal of knowledge and a very reassuring presence as you speak about things. That's why you're so successful at things that you do. I'll ask you the same question I asked Alan, since we've got a couple of minutes. Looking at it from somebody who's worn both hats as a practicing attorney and an educator, what grade would you give the IDA, or what grade would you give disability law, and what ways might you strengthen it? And a question came in just as I was saying that. Are you aware of any recent cases on the negligent supervision, I guess, policies where district incurred legal liability as negligent preparation of an IEP? Let me try to answer that, and I'll let you answer. That would typically fall under the area of educational malpractice, and the courts are very, very reluctant to grant relief for educational malpractice. However, while they don't call it negligence or malpractice, many of the lawsuits that are filed raise just that charge, that somebody did not meet the professional standards. So while it's not phrased as negligence, it is couched in terms of an inadequate IEP and results in a great deal of litigation. I hope that answers the question. If it doesn't, please type back an answer while Jillian is talking. We still have a couple of minutes to respond. I think that responded, but I'll let Jillian answer as well.
I think I agree with your assessment of that question, Charlie. To answer on the nose, I'm not aware of any cases that you've described therein, but Charlie has adequately described kind of what that claim might look like. It's sort of under a different legal theory. But to answer your question, Charlie, about what grade would I give, I'm with Alan. I think it's a C, and it's, I give it a C because I think the law is average. And I think that it has the ability to be implemented very well in the hands of the right people. But it also has the ability to be below average if attempting to be implemented by folks who either are not knowledgeable about it or, for lack of a better term, don't care enough to spend the appropriate amount of time to make it work correctly. So, I'll just echo what Alan said. I can say ditto. I kind of wish Congress would call you guys to see if they could work it out.
It's not gonna happen anytime soon. A last comment to the last questioner. I blanked for a name on his name, but the late Judge Posner of the Seventh Circuit in an educational malpractice case, actually out of higher education, he said it's a theory well loved by the pundits, but not by the courts.
Yep.
So it's not going to go too far. Jillian, I thank you very much. I know you're not able to stick around. You've got a client, got to pay those bills. But we do appreciate taking time out of your busy schedule to give us some insights. For everybody else, we'll come back at about 2:45. Jillian, if we don't see you before then, I'll see you down. And we have a tough life. We have to go to Orlando for our next speaking gig together.
All
Dirty
right.
job, and somebody's got to go see Mickey, eh? But everybody, thanks for listening in to us. If you have any questions, please feel free to shoot them to me or at the chat line. We'll come back in 2:45 with an international panel, then a wrap-up panel at 3:30. We thank you for your participation and attendance. And Jillian, we thank you. Good luck with your client. Enjoy what looks like going to be a nice weekend. I
My
see you
pleasure,
looking out
sir.
the window at a beautifully blue sunny sky. Not often I want to be outside, but it's a nice cool day. Jillian, thanks. We'll see everybody back in a few minutes. Bye-bye.
Thank you. Take care.
We're all good, Charlie.
Okay, thanks. Hi, good afternoon, everybody, and welcome back. It's 2:45 Eastern time. I believe that's 4:15 in the morning in Adelaide, Australia, where Paul Babby is, and 3:45 in the afternoon in Brazil, when Nina Hanieri is. Bill Smales in the same time zone as we are. Bill, if you want to show a picture for just a minute. As we've done in the past, one of the things we try to do is give people a perspective a little bit broader than just our own in the United States. And some years ago, I edited a book on the law of special education. And so it's fortunate enough that we have three speakers who are very knowledgeable on the point. It's going to be Paul Babby from the University of Adelaide, Australia, Nina Hanieri from University of Sao Paulo in Brazil, and Bill Smale at Trent University up in Canada. I'll introduce each one as they come on. Over 20 years ago, I was in Rome, and I happened to meet Paul Babby in a very chance opportunity. We've written together, spoken together, visited each other's homes and campuses. Been a pretty neat experience. Paul is the ALS Professor of Property Law and Associate Dean, Director of the Law and Religion Project, and of the Research Unit for the Study of Society, Ethics, and Law at the University of Adelaide. He's a fellow of the Australian Academy of Law. He has spoken with us on other occasions. And for the next 5 or 7 minutes, Paul will speak with us about the status of the law of special ed in Australia. He'll be followed by Nina Hanieri and then Bill Smale. And we will ask them to stick around for the general panel at 2:30. They'll each have about 5 to 7 minutes to speak. I will mute myself and only come back on if and when there are questions. With that, Paul, thank you for staying up until the middle of the night or taking a nap to get up, whichever you may have done. We look forward to hearing what you have to say. Paul, the floor, so to speak, is yours. Good morning and welcome.
Thanks very much, Charlie. I'm just going to share my screen. So you should be seeing my slides now, I hope. Can you see those? Yep. Great. Thanks very much. Thanks a lot, Charlie. Thanks for the opportunity to join you. Yeah, it's just gone just after 4:15 a.m. here on Saturday morning in Adelaide, Australia. So as I said to Charlie, when I sent him my slides yesterday, I said I make no warranties as to the anything that I might say at this time. Nonetheless, I do have about probably 5 to 7 minutes, and this is indeed a very brief overview of special needs education in Australia. So I'm just going to start quickly with a bit of context. And this is data drawn from between 2018 and 2022. In Australia, 1 in 10 or 380,000 school-age students between 5 and 18 have disabilities. 9 in 10 of those students go to mainstream schools. And as you can see, 29% of teachers work in classes with students that have an identified disability. 74% of teachers are trained to teach in mixed ability settings, but only 38% of those teachers on average feel prepared to teach in those settings. So in relation to the law, or the position, the legal position with respect to special needs in Australia, that's really covered in both legal and policy formulations. And the first point to note is that Australia is a constitutional federal, and I should probably say on the slide there, federal monarchy. And I say note, not a republic. This is, I think, something that causes confusion both in my native Canada and in my adopted Australia. We are still, in fact, a constitutional monarchy, which means that for the first time in my life, whereas I should say, whereas in the United States, the head of state changes once at least every 8 years. In Canada and Australia, for the first time in my life, and I'm 56, the head of state changed very early in the morning here in Australia on the 9th of September. And that was the first time indeed in 70 years that the head of state had changed. So of course, as everybody is now aware, Queen Elizabeth II passed away and Charles III acceded to the throne at that point. And so whoever the monarch of the United Kingdom is at any given time is also the head of state constitutionally of both Australia and Canada. So we are, but anyway, that's not relevant to anything else I'm going to say today, but I thought that'd be an interesting side note just at the outset. So we are constitutional federalism, and therefore, as anybody will know that is familiar with the federal system, such as the United States, that means that elements of special needs law are contained in both federal, or what we usually say in Australia, Commonwealth. That means the federal government, and state law and policy. So federal law consists of 3 different categories of law, what's called Commonwealth discrimination law, and in particular, the Disability Discrimination Act of 1992, which is a Commonwealth piece of law. And then also 2 policy documents, the Disability Standards for Education 2005, or the DSE standards. Those were established by the Attorney General of Australia in response to the High Court's decision in Purvis and New South Wales of 2003, which I suppose in a way is the Australian equivalent of the Rowley case. And that was, the High Court was interpreting the Disability Discrimination Act in relation to a special needs education setting. And so these standards were promulgated by the Attorney General in response to that decision of the High Court. And then the second policy document is what are known as the National Principles for Child Safe Organizations of 2018. And then, so in addition to that federal law, there's also state and territory anti-discrimination legislation, which also plays a role in this area. So just as an example, in my state where I live, South Australia, we have what's called the Equal Opportunity Act of 1984. Every state and territory has a counterpart piece of legislation to that sort of anti-discrimination legislation. So you have a federal and a state regime of law that deals broadly with special needs education. Just want to say give a bit more detail then about each one of those bodies of law, and in particular, the Disability Standards for Education of 2005. So I've just got a few points there that draw on those standards. One is that the standards are really trying to give effect to the idea that all students with a disability must be enabled to participate in education on the same basis as other students. And then the second point is probably the most important here, and that is trying to give effect to the Disability Discrimination Act in relation to the special needs education setting specifically. So what the standards do is clarify, firstly, the rights of students with disabilities, secondly, the obligations of education and training providers, and third, what are the reasonable accommodations that must be made to achieve those outcomes in the special needs education setting. So also in the standards are guidance notes, which assist in the application of the DSE standards. And the 5 standards are, I've listed them there, enrollment, participation, curriculum development, student support services, and the elimination of harassment and victimization. Nonetheless, I've just cited there at the bottom of the slide, Tamara Walsh and Catherine Thomas have sort of analyzed all of the litigation since the disability standards were put into place. And there's very little successful litigation that tends to either interpret or enforce those standards in Australia. The other policy document that I noted at the outset, which is part of the federal regime, are the Australian, these were promulgated by the Australian Human Rights Commission, and those are the National Principles for Child Safe Organizations. And those were put into place in 2018, and they were really a response were a response to the Commonwealth Royal Commission into Institutional Responses to Child Sexual Abuse, which was 2017. All of the Commonwealth, I should say the Commonwealth and all states and territories have confirmed their commitment to those principles. And what they really contain are two components. One is what's called the Wheel of Child Safety, which has 10 principles for safe, happy, and engaged children. And then the 10 national principles for child-safe organizations. And I've just reproduced these images come directly from the national principles. So that's the Wheel of Child Safety, which contains the various elements for safe, happy, and engaged children. And then there are 10 principles, which I don't propose to read out to you, but you can see just as some examples. Child safety and well-being is embedded in organizational leadership, governance, and culture. That's principle number 1. Principle number 4, equity is upheld and diverse needs are respected in policy and practice. And number 9, implementation of the national child safe principles is regularly reviewed and improved. And 10, policies and procedures document how the organization is safe for child and young people. So you see that gives just a flavor of what those national principles for child safe organizations are. So that leads to a question then, which is, are special needs education requirements being met in Australia? And in fact, there are 4 studies which have been conducted over the last few years in relation to that question. The first is the Senate Standing Committees on Education and Employment released a report in 2016 in relation to access to real learning, the impact of policy, funding, and culture on students with disability. And in Chapter 5 of that document, the Senate Standing Committees found that increased funding and policy reform is necessary better to support students with disabilities. So they found that there were some limitations or failings in relation to providing for students with disabilities. So that was the Senate Standing Committees. The second study was conducted in 2020, and that was a review of the DSE standards, and that was conducted by the Australian Government Department of Education. And they issued 13 recommendations, but those reflected 4 reform directions. First, that there needed to be empowering and supporting of students with disability and their families. Second, that there be strengthening the knowledge and capability of educators and providers. Third, that there be an embedding of accountability for the standards throughout the education system. And fourth, the 4th reform direction was that there be a building of awareness and capability in the early childhood education and care sector. So that was in 2020. And then last year, the Australian Coalition for Inclusive Education released what is called a roadmap for achieving inclusive education in Australia. And there were 6 key pillars for improvement that were indicated in that report or roadmap, that there be an ensuring of inclusive education, that educational institutions phase out segregated education. Third, that there be an increase of educational outcomes. Fourth, that educational institutions stop gatekeeping and other discrimination. Fifth, that there be an elimination of restrictive practices. And finally, that there be a prevention of suspensions and expulsions. And then finally, this year, just earlier this year, the Commonwealth Disability Royal Commission, in its public hearing number 24, focused on the experience of children and young people with disability in different educational settings. And so just to conclude then, this is from a paper written this year by Annalise Wright and Craig DeCruz. And this is a quote, and I think that this really summarizes, I think, where things are at. Well, we have, I think, a high degree of commitment to providing for students with disability and special needs educational environments. Wright and DeCruz say that schools need to prioritize writing and establishing effective policies that comply with national and state requirements and seek to ensure that students with disability receive quality of education that is comparable to their peers. Schools also need to invest resources into training and supporting their teachers, noting that nearly 2/3 of all teachers of students with disability in a class feel that they are insufficiently prepared to teach these children effectively. So circling back to that initial data that I had up on my first slide, And then writing decrees go on to say that in addition, schools must use their Commonwealth and state or territory funding to provide all students, including those with disability, with appropriate equipment and general resources so that all students are being educated to achieve their best. And finally, that teachers be trained and supported who are given the resources to best teach their students with or without disability, and that will no doubt better enable their students to achieve to the best of their ability. So really the conclusion is then that there needs to be, I think in the view of most of the studies that have been conducted recently, certainly legal and policy reform is required, but that it is probably not enough. There needs to be further policy reform and a more appropriate use of Commonwealth and state and territory funding in relation to educational opportunities for all students. So yes, there is what appears to be a moderately comprehensive regime, both at the state and federal level in relation to special needs, but there's probably more that could be done in Australia. So thanks very much.
Thanks, Paul, and I hope you'll stick around with us. It's now my pleasure to introduce Nina Beatrice Stocco-Ranieri. She's an associate professor too at the University of Sao Paulo School of Law, arguably the best school in South America. She is in the Department of Public Law. She also occupies the UNESCO chair on the right to education and is a senior researcher in its Center for Public Policy. Nina has worked both at the state level of government and in public education in Brazil. She has published and spoken widely throughout South America, Europe, and also in the United States. She writes widely as well, very well accomplished. And with that, I'm happy to turn it over to you, Nina. I look forward to hearing what you have to say. Thank you for joining us. Did we all just freeze?
Okay. Is that okay, Charlie?
Yes, now I can hear you, Nina. Thank you.
Okay. Very nice to be here. Charlie, thanks for the invitation and good afternoon, everyone. This is a very in Brazil. Brazil is a constitutional federation, a republic, and in 10 days we'll have elections for the presidency. So this is a very busy period, a very challenging period considering all the political circumstances. Okay, so in Brazil, special education is a constitutional right and an obligation of the state and the family. And it is defined as a modality of school education, preferably offered in the regular school system to all special needs sources for special education besides the federal constitution, including the UN Convention on the Rights of Disabled Persons, considered as a constitutional amendment to our constitution, and the 2015 Statute for Persons with Disability, which brings important advances in the special education law, such as prohibiting private schools for charging additional fees for implementing accessibility features, for example. Since the '88 Constitution, special education legislation has been interpreted by the courts in the light of the constitutional principles of non-discrimination and the guarantee of equal conditions of access and permanence in school to all. These two principles brought the original legal scope of special education to what is considered an inclusive education, which from a social perspective points to the elimination of barriers and the promotion of accessibility rather than separation of students with and without disabilities. In 2020, the Supreme Court confirmed this interpretation in the case of National Policy for Special Education, in which a political party claimed the unconstitutionality of a federal decree that provided for the segregation of students with disabilities, among other illegal measures. The decree was considered unconstitutional and was suspended immediately. Now I'd like to look at the rights of students with special needs in Brazilian law. In short, the special needs students are entitled to receive a free and appropriate education, which includes the following rights: free and inclusive public education, preferably in the regular education system, private or public, a guarantee of equal conditions of access and permanence in school, giving an adequate opportunity for each student depending on their singular needs, priority in the fulfillment of the right to education by the government authorities, and to be protected from all forms of negligence, discrimination, exploitation, violence, cruelty, and oppression. This is the broad frame of the special education law. Well, in the last 5 years, the number of enrollments of students with special needs has grown about 34% nationwide, according to official data. In the same period, the percentage of those who are included in regular classes has also increased from 87 to 92%. According to this data, the highest rate of students in regular classes, around 97%, is in public schools. So private schools doesn't deal with all this situation as much as the public system. And public systems in Brazil are mostly state and municipal. Nonetheless, states doesn't legislate on special education law. Only the federal system legislates. Well, at the same time, in the last 5 years, and proportionally, the barriers to inclusions have increased. Difficult access to most places, something that has grown during the pandemic, lack of adequate didactic material, lack of teacher support in the classroom, and lack of suitable public transportation are some of the most critical problems. These barriers affected disabled persons of all classes in different of economic or social backgrounds. However, this is especially dark in situations of socioeconomic vulnerability. Special education in Brazil began in the 19th century, but it was only in the second half of the 20th century, especially in the 60s, that education laws regarding special education were enacted due to the many international treaties that Brazil signed at the period. However, it still hasn't produced the desired results due to many reasons, like the relative newness of the law provisions, as well as a lack of awareness of the rights on the part of a considerable portion of the population. Exclusions of rights continues to be grave. One of the reasons why the rights of the special needs students are not complied with is the broad spectrum of criteria in the identification of the needs for special treatment, whether on the part of the governmental authorities or on the part of the school. Another problem is to assure all these rights in the public system, despite the fact that the public system holds the most, almost 97% of the disabled students, due to many reasons such as funding, training, identification, assessing, lack of didactic material, and support services, among others. In spite of the progress that has been made in the area, due to the laws enacted since the 60s, as I mentioned. This is why in the domain of the public ministry, it is included the protection of special education students the protection of them is made through lawsuits and public hearings, and the repercussion of which go beyond the limits of class and individual actions. Neither access to schooling nor compulsory fundamental education necessarily answer the constitutional principle of equality in education. The right to special education is only assured if schooling aims at preparing the disabled persons both as citizens and professionals. If special needs students are not separate from other students, and if special treatment for reasonable adaptation is considered a plus and not an alternative. Brazil has many educational problems, especially at the north of the country, due to remote areas and rural areas in general. But the problems regarding special education covers all our territory, and this is an issue that deserves special attention from the governments, especially from federal government. So Charlie, this is a brief panorama, but I'm online to any questions and discussions necessary.
I was muted, sorry. Thank you very much, Nita. After Bill finishes, we'll open up for questions and answer. It's not my pleasure, and we did this alphabetically, Bill, so we're leaving you as cleanup hitter. Professor Bill Smale, William Smale, is a professor in the School of Education and Professional Learning at Trent University in Peterborough, Ontario, where he also continues to play ice hockey. Probably gave up an afternoon game today to be with us. Bill was recently elected to the Board of Directors of the Canadian Association for the Practical Study of Law and Education, the Education Law Group in Canada. He writes extensively on education law, ethics, professional conduct, and some related areas. He also is a very good speaker, has spoken widely throughout Canada. And on that note, I turn it over to Bill. Bill, you got about 7 or 8 minutes to get or so. Then I'll invite Alan Osborne back in. And if anybody else is here who spoke with us, and we'll open it up to general questions. But I will have a question for the 3 international speakers to open that up when Bill is done. So
Okay.
Bill, we look forward to hearing what you have to say. Thank you for joining us.
Great. Thank you for inviting me, Charlie. So I'm just getting over a cold, and yes, I am missing hockey today. So just for you, Charlie. So anyway, so my name is Bill Smale, and just to give you some context, I did work in the spec ed area for about 15 years, both at the elementary and secondary level. And in fact, I also taught young offenders for a few years. So I have that background in spec ed. Now, just to say a few words with respect to the Canadian context, in Canada, we do not have a federal Department of Education. Each province, there are 10 provinces in Canada and 3 territories. Each province and territory has their own Department of Education, and hence each province looks after special education. Now, that all being said, we do have a Supreme Court in Canada, which oversees the whole country. And although education is a provincial responsibility, it's becoming more national in scope as the Supreme Court rules on more and more cases. Because once the Supreme Court rules in Canada, that means every province and territory has to follow suit. So you can see where, yes, special education is a provincial responsibility, but things are changing slowly with respect to it becoming national in scope. Now, what I want to do, instead of running through a lot of policies, I want to talk about, I don't think I'll have time to get into many cases, but I want to talk about a couple, maybe I have a few, but maybe I'll get through one landmark case of what the Supreme Court that has to do with spec ed. So many cases that have to do with spec ed that have landed on the doorstep of the Supreme Court, but there's a couple of really important landmark cases. So just cut me off Charlie, if I'm going too long. So the first case that I want to talk about is a Supreme Court case called the Emily Eaton case. And in this particular case, Emily Eaton was a 12-year-old student who had cerebral palsy. So she was unable to communicate through speech, sign language, or other communication systems. And Emily also had visual impairments, mobility impairments, and she was wheelchair bound. Now, this particular student was initially placed in the integrated classroom, or I guess we could say the regular classroom, but after 3 years, the teachers decided that was not the best placement for this student and decided to move this student into a specialized classroom. Mom and dad did not like that. They were really upset with that. So the parents, they were Clayton and Carol Eaton. They disagreed with the teachers and appealed this decision to something called an IPRC. I'm not sure if they have that in Australia or the United States, but it's Identification, Placement, and Review Committee. And that's usually made up by teachers, principals, vice principals. The parents are there, special education teacher, and the teacher. So that as a group, they make this decision, what is the best placement for the student? So this IPRC committee, they met and they decided the best placement for the student, Emily Eaton, would be in this this specialized classroom. Now, this IPRC, they look at many different areas. They look at the academic performance of the student, cognitive process of the student, behavioral problems, social skills, emotional problems of the students, and physical problems of the student. So the IPRC committee, they decided that the best placement for the student would not be in the regular classroom. So basically the parents were unsuccessful and they challenged this and took this to the Ontario Special Education Tribunal. The Ontario Special Education Tribunal confirmed the decision of the IPRC. And again, they said it was not in the best interest of the child to be in the regular classroom. Again, the parents were unsuccessful, and then this decision was appealed to the lower court. The lower court agreed with the decision of the Special Education Tribunal. And again, they said it was not in the best interest of the child to be in the regular classroom. The parents, again, were unsuccessful. They appealed this to the Court of Appeal, the Ontario Court of Appeal. Now there's 3 judges listening to the case, and the Ontario Court of Appeal overturned the decision. And they said, absolutely, it is in the best interest to put the student back in the regular classroom. So obviously the parents are happy with that decision. The board was not happy, and the school board appealed that to the Supreme Court of Canada. Now, the Supreme Court of Canada, they restored the original judgment. So basically the parents were unsuccessful, and the Supreme Court noted that integration can be either a benefit or a burden, depending on whether the individual can profit from the advantages of that integration. So that was a case that many people were upset with, and that sort of opened things up for cases similar to that down the road. Now, I'm just looking at the clock there. Charlie, do I have time for one more Supreme Court case or not?
Yes, I muted in terms of, but go ahead for another case.
Okay, so I'll make this one a little bit short. So this is a really interesting case. This is the Jeffrey Moore case. So Jeffrey Moore received public education. So this case happened in British Columbia province in Canada. So Jeffrey Moore received special education as a public school student because he had dyslexia. Now, this special education program that he attended in his public school could not meet his needs. So this particular student was transferred to a local diagnostic center. So this was funded by the Board of Education. So at the diagnostic center, a very successful education program was put in place for Jeffrey Moore. However, because of financial cutbacks, provincial cutbacks, they soon closed this diagnostic center, and basically the student was left with no spec ed program. So Moore's parents were forced to pay for Jeffrey to attend a private school where he could get the remedial help that he needed. Now, at this point, Jeffrey Moore excelled. He moved into this private school. He excelled, and in fact, he won the most improved student. So this program was really beneficial to him. So eventually, Jeffrey Moore's father filed a complaint with the British Columbia Human Rights Commission and the school district, basically the government, and the grounds for the complaint was that Jeffrey Moore had been denied the services. So now the parents were paying for these services, and they said, no, the school board should be paying for these services. So this went in front of a human rights tribunal, and the tribunal found that the school district and the government of BC discriminated against Jeffrey Moore when it closed the diagnostic center. And they said, yes, okay, that's your right to close the center, but you have to find an alternative accommodation for this student. So the tribunal sided with Jeffrey Moore and his parents. So as a remedy, Jeffrey Moore's parents received reimbursement for his tuition at this private school. They received $10,000 in compensation for pain and suffering. They received the transportation costs. At this point, the decision was then appealed to the BC lower court, and the BC lower court overturned the tribunal's decision, and the judge noted that Jeffrey Moore had not been discriminated against, as the school closure affected all students, not just Jeffrey Moore. So again, this was appealed to the BC Court of Appeal. The BC Court of Appeal upheld that decision, and the appeal court ruled that since Jeffrey received the same treatment as other dyslexic students, there was no individual discrimination. So they couldn't buy that argument. Then this got appealed to the Supreme Court of Canada, and the Supreme Court of Canada ruled that both the lower court and the Court of Appeal had erred in their judgments, and the Supreme Court of Canada ruled that every student should receive full benefits of an education, and that it's up to the province excuse me, to provide those. Even if a facility closes, they still have to provide those special education accommodations. And finally, the Supreme Court held that special education is not a luxury, but rather a ramp that provides access to basic education. So those are two landmark cases that have went before the Supreme Court in Canada. So I'll turn that back over to you, Charlie.
Bill, thanks very much. Bill, Nina, and Paul and Alan, if you want to jump in as well, we can just kind of flow into the general Q&A at the end. Let me ask all of you, Bill, Paul, and Alan, same thing I asked Alan earlier. Nina, I think I missed you there. How effective are the special ed laws in your nations? Where would you rate them? I had asked Alan and I guess Julian earlier, they would give the IDA a C. Not to be a difficult, I would probably give it at least a B. Because if you look at what happens in the United States in 1973, 2 years before the IDEA, then the Education for All Handicapped Children Act came into effect, less than about half of all kids were receiving what today would be considered an appropriate special education. So considering where we came from, I think we've done pretty well. When I was in college, it was a gentleman's C, was probably the equivalent of an even lower grade. So I would give it a little bit higher. But let me start with you three, and then we can open it up. Bill, Nina, Paul, whoever wants to jump in first. How effective would you say your laws are?
I can start, Charlie. I would say in Canada, the law, I would probably rate it maybe as a B, a C+ to a B. And the big factor is around money. That's the big factor. And I'm thinking of another case that I probably don't have time to get into, which is the Otten case. Again, this was a case out of British Columbia that went all the way to the Supreme Court. And this case had to do with the special treatment that an autism student needed. And the province and the school board were saying that it's just too expensive. We can't afford this treatment. So mom and dad moved the student to, again, a private school, and then tried to sue the government unsuccessfully. But again, the public school system just couldn't afford. I think it was $60,000 a year it was going to cost for this one student. And the school board said, we just can't afford that. So I would say money is a big limiting factor in this country anyways, in Canada.
Well, it is in the United States as well, where those services are provided, it's pretty poorly underfunded. I'll ask Alan about that in a couple of minutes. Nina, how about Brazil? How effective would you rate it? And I know you make the distinction between, say, Sao Paulo, Rio, and maybe Brasilia, but then some of the rural areas, it's much less effective. But I don't want to put
Well-
words in your mouth. What do you think?
Well, I would say C. I would say C, and even in São Paulo state, which is the richest state in the country, and São Paulo state has the most developed public system in the country. But anyway, I teach in a public university, and I don't have any disabled student. We don't see disabled students around the campus or around the university. And I believe we are still in the beginning of this, well, trying to attract special needs students even to schools. And despite the fact that considering the whole country, the public system has more than 90% of the disabled students, but still it's just a few. Teachers are not trained, and there is a resistance. There is still a resistance among the other students or the parents to receive.
Are the teachers resistant or the school leaders?
In some ways, it depends on the region. But still, I mentioned a federal decree that tried to separate again students. 2020 federal decree that established a new national policy concerning disabled students and tried to segregate them again. And it was a political party who questioned the constitutionality of this decree at the Supreme Court, and the decree was suspended. But this is just a glimpse of how things are going this last 5 years, let's say. And money is, of course, is a big issue. Money, certainly, but mentality. We are facing terrible times, and mentality is against and trying to segregate disabled students. So thanks to the courts and thanks to the public ministry that is still fighting against this kind of view.
Do you see things in Brazil as on an upward slant? Or is it more going down, or is it staying steady?
We're going down.
Doesn't sound great. We'll
No.
come back to you. Paul, what do you think? How about Australia?
So I don't think I don't feel qualified to sort of give it a letter grade in the same way that the others
That's
have.
okay.
But
How do you
what
just
I-
evaluate it overall?
what I would say is that I think that what you're dealing with in Australia is sort of, I guess, more generalized pieces. So there's not anything constitutional, you know, in the same way that there was in Brazil. There's not a constitutional right. There's not been really any litigation other than the Purvis and New South Wales case in the High Court, which is the functional equivalent of the Supreme Court of Canada or the Brazil Supreme Court. So you've got a federal piece of legislation, the Disability Discrimination Act. And then, as I said, the disability standards for education, which have been implemented to try and clarify the application of that, you know, general piece of legislation in the special needs education setting. But in 2015, Walsh and Thomas, they looked at in the primary school setting. They said between 2003 and 2014. With these new standards in place, only 28 complaints of disability discrimination in primary schools were heard by tribunals, and of those, 18 were dismissed outright. In 4 cases, the matter was not finally determined. There were only 4 cases in which a finding of discrimination was ultimately made, and the complainant obtained a remedy. And in the other 2 cases, applications for approval of a settlement were granted. So there's been very little, I guess, interpretation either in tribunals or in courts of those DSE standards. But those are, of course, also just, as I said, an attempt to use a general piece of legislation and apply it to a specific setting. And so that's why I think in my conclusion, I was getting at the idea that, legal reform may be necessary in order to tailor something that is addressed specifically to the special education needs setting. And as all of the other speakers have said, money is obviously an issue. That was one of the big conclusions that I found in looking at this, is that money is an issue. Obviously, there's not enough, and that money which is there is perhaps not always targeted in the best way that it could be. So like I say, I don't feel like I can give a letter grade, but I think it probably is a bit of an imperfect system. That's the way that I'd put it.
So does it pass? Is it a high pass? Is it a low pass?
I think it probably passes. I think that's one. Australia, for others listening as well. I mean, one of the things that is always surprising to people to hear about Australia is that we are the only Western liberal democracy that does not have a comprehensive protection for fundamental human rights. There's nothing in the Constitution. There's nothing that is a comprehensive piece of legislation at the national level. So when I talked about that federal discrimination law, and you've got the Sex Discrimination Act, the Racial Discrimination Act, Disability Discrimination Act, that's very much a piecemeal approach to protecting rights, and it's an imperfect approach. But what I would say is that in the disability discrimination area, that's probably one of the areas where, in an imperfect system, that's a pretty, it's a good piece of legislation, and it operates at a national, and it has a national application. But still, when you then try to apply that in specific settings, then that's when the cracks start to appear, I think. So I definitely think I would give it a pass. In sort of an imperfect system, it gets a pass. But I'm an advocate for a national Bill of Rights that's in the Constitution. Some people agree, a lot of people disagree with that. I know that sounds surprising to people that have a federal Bill of Rights, but I think that's one of the first steps towards trying to nationalize some of this. So yeah, that's I suppose what I'd say about it.
Okay, sounds good. One of the topics we thought about including, and we removed it pretty much near the end, was the impact of special education, or the delivery of special education, in faith-based schools. As I sit in my office, I look right across the street here in Dayton, and it's a Roman Catholic school, not 100 yards, 100 meters from where I sit. If kids attend faith-based schools in the United States, the way the regulations work, and Alan and I have done some work on this, the likelihood that they'll be served is pretty low. In Europe, Nina and I have a mutual friend, Jan de Graaf, whose children in Belgium, Jan was unable to make it today, children attended faith-based schools funded by the state. Special ed services are provided. It's certainly a tough question. If parents choose to go to a faith-based school, they give up the services, but should the services perhaps follow children wherever they go as a kind of a voucher? Canada's got a system that allows for some of that in regular education. I know Australia does. I think Brazil to a degree. But what do you think about funding services in faith-based schools? About 12 to 15% of kids in America do attend non-public schools. Depending on whose numbers you believe, recently, with the pandemic and so many closures of public schools, more parents seem to be opting towards faith-based schools. I received a press release. I added 2 journals, so I get a lot of them earlier this week. And Christian schools have experienced a pretty significant upswing in the number of children who are enrolled in their schools, because many of them were reluctant and did not close down. So do any of our 4 panelists who are still here now have any thoughts on whether special ed should be delivered only in public schools, or if parents choose to opt out for faith-based reasons, should those kids continue to be served wherever they attend school? And I'll leave it open to whoever wants to speak first.
Well, Charlie, in Brazil, we have in the health system, and even in the education system, the possibility of public funding of the so-called social organizations. There are many hospitals directed, administrated by this kind of social organizations, and some of them are faith organizations. So in the health system, there is laws considering all the situation, and it's very common all around the country. The health system in Brazil, in fact, start with the so-called Santas Casas, holy houses for health. So we have something like that, and I think it would be possible to have in the educational area as well. Nurseries are receiving public funding, including faith-based nurseries, to fulfill the lack of spots in the public system. So I think it would be possible, sure, legally speaking.
You say it's possible. Do you think it's likely?
Yeah, likely.
Okay. Paul or Bill or Alan reading the screen across the top in the order of is up there?
Just a quick comment on that. So in Ontario, which is the biggest province in Canada, we have a public system funded by the government, but we also have a Catholic system funded by the government, equal funding. So if a student goes from the public system to the separate system, all of that funding is transferable. So it's very, very seamless. And Paul may know better in Alberta, because I think, Paul, you lived in Alberta, but I think Alberta also still has a public system and a separate system, which are 100% funded by the government. So other religions are funded, just Catholic system is funded. And my general view is I think it's a good idea that these special education services are transferable from one school board, from like the public school board to the Catholic school board.
Sure. And I believe there's also some of that in Quebec and in British Columbia.
There could be in Quebec. I know generally in Quebec, they just have one public system, and I don't know if they fund other systems, but maybe British Columbia still does a little bit.
Okay.
That's definitely true in Alberta. That's absolutely true. I think it might be true in Saskatchewan as well, but definitely Alberta, yes.
What do you think about that, Paul?
In Australia, I mean, I think that the same sort of, I mean, it's things are a bit messier in Australia in terms of who funds what, but I mean, there tends to be federal money going to most schools, whether they are state or non-state schools in Australia. And so, you know, the standards that I was talking about would apply equally across the board to all of those schools. So I think that those sorts of things have to be happening in schools, whether they are what you'd call state schools, certainly in state schools, but in private schools as well. So I think that the standards apply. The funding is a little bit messier in terms of how that works.
And next week, I'm doing a presentation with a mutual friend in Sydney, and he had data, Keith Thompson, that about 35% of funding goes to faith-based schools in Australia.
Yeah, that's
that
right.
would
Yeah.
not happen in the United States. We have
No.
an very indirect. Alan, what do you
Yeah.
think? You and I have worked on this. I didn't mean to interrupt you there, Paul, if you wanted to finish.
That's right.
You know, again, getting back to the issue of we are not really fully providing students with disabilities an equal educational opportunity in the public schools. We certainly are not providing them an equal educational opportunity in faith-based schools. And I agree with Charlie on this, that the parents who choose, you know, exercise their right to send their children to faith-based schools should not have to make that choice between a faith-based school and getting appropriate services for their children. So I think we certainly should be doing more. That would require a change in the IDEA. I don't think there's a First Amendment constitutional ban. And you know, there's been a couple of cases, you know, dealing specifically with remedial services or special education services that I feel certainly would allow it. We had the recent case, Charlie could address it better than I can, up in Maine, where they're, you know, allowing children from a school district that doesn't have its own high school, basically to attend a faith-based high school and have the tuition paid by the municipality. And certainly with our current Supreme Court, I don't think they would ever find it unconstitutional for us to provide more services to special ed kids. So I think it can be done. I think it should be done.
Yeah, I think everybody's touched on it. There's an old movie that you might be familiar with, Cabaret, and the once always money makes the world go round. You know, in a perfect world, that would happen. And you and I have written about it, and I agree with something you'd written. Not a matter of the public school loving the kids in the faith-based schools any less, but their obligation to serve the kids in your school. And it put the educators between a rock and a hard place because they want to serve everybody, but you do have an obligation to serve those who can attend your schools. A kind of general open question. We have about 15 or 20 minutes left. And I know it's been a long day for everybody, and I appreciate you sticking around. But looking forward, what's the future of special education in our countries? Will our legal system continue to provide the services, the level of education kids need? Or are we likely to limp along with just doing a little patchwork here and there, not ever meeting the promise of a Rowley? Or when I write and speak about it, 1954, Brown versus Board of Ed opened up an era of equal educational opportunity. It introduced an era of great promise, but we've not met that promise fully. There used to be a commercial, I think in the 1970s, for cigarettes, Virginia Slims, you've come a long way, baby. We've advanced, but I'm not sure we're there yet. Will we ever get there, whatever that means? Alan, you're on the screen if you want to go first, or Nina, Bill, Paul, anybody want to join in?
You know, several people have mentioned that it does come down to money. And there's no question about that. We don't have sufficient funding in many school districts to provide quality education for the students in general, let alone the more expensive special education services. So I see that as a major obstacle. And until we decide as a country that we're going to provide equal educational opportunity, across states, across school districts, and across all groups of students, we're not going to reach that.
I think you're right. Nina, Bill, Paul?
Well, I agree with Alan, absolutely. But on the other hand, people are getting more conscious about their rights. So maybe a pressure could help to increase the fulfillment of all these necessities and needs of the special education and the students with disabled students, sorry. But I agree with Alan.
Nina, thinking of your situation where you say there's a certain amount of resistance, if I heard you correctly, towards special education in many schools. I don't think that happens so much in the United States. I'm not going to suggest we're perfect. I think secondary school teachers tend to be a little bit more hesitant than elementary and middle school teachers. But how do you think we get the teachers on board? How do we get the educators on board? If we can't convince them to support this, how are we going to get the general public to provide support? Because so much of it, it seems to me, comes from shaping the attitudes of kids. And as they grow up, hopefully children can begin to change things. And reflection. Plus, you've done a great deal of work internationally, continue to, on education as a fundamental right. We've spoken in conferences on that. How do we expand that notion of education as a fundamental right to cover kids with disabilities, some of the weakest kids, unfortunately, physically and or intellectually in our society, who are going to be left behind? You know, we called our statute No Child Left Behind. What are we going to do to not leave any kids behind?
Well, I think, in my opinion, inclusive schools are the best measure to get people involved with all these necessities and to get to know all these necessities and try to be more empathic and more participant in helping people to be educated at least. But as you said, we have to begin with the children and changing mentalities, changing culture. And I think the segregate mentality is a very old and negative mentality, and we have to change the culture.
Do you think we'll see much change in positive direction in the coming future as the younger generation gets more exposure?
Yes, I think so. And participating and feeling the difficulties and seeing the difficulties and not living in a bubble.
Sounds good. Bill or Paul, what do you think?
Just a comment there, Charlie. So Nina mentioned pressure and you mentioned resistance. I think there is a lot of that going on in schools. And I think sometimes it takes the courts to intervene to move things forward. Otherwise, nothing happens. And I'm just thinking of the Canadian context. If it wasn't for the Supreme Court, I think we probably would be like 20 years behind other countries in Canada. And for those that aren't familiar with Canada, in Canada, we have something called the Canadian Charter of Rights and Freedoms. And again, every single province, even though education is a provincial responsibility, every province has to follow the Canadian Charter of Rights and Freedoms. And Section 15(1) of the Canadian Charter of Rights and Freedoms talks about equality, and it basically says that you can't discriminate based on mental or physical disability. So the courts do intervene with these spec ed cases and they set a precedent. So I think in many cases, things wouldn't move forward unless the courts did intervene in some of these cases.
You know, you mentioned the Charter of Rights. Similarly, in the United States, education is not a fundamental right in the US Constitution. However, starting with Brown and some other lawsuits, if it involves a fundamental right that states confer, such as education, then you get it into federal courts. And our IDEA confers a statutory right on those kids. So we have a great deal of litigation. Alan's devoted the better part of the last 35 years to writing about that stuff. There's just a great deal of litigation in our country, the United States. Thanks, Bill. Paul, any thoughts on that?
Yeah, well, that's a good, I'm glad that Bill raised that, because that's exactly the point I was making earlier about the fact that Canada does have a Charter of Rights, which came into force in 1982. I mean, Australia, that was my point earlier, that Australia does not have any sort of document like that in its constitution. And so that is a drawback. And as I said earlier, that's something that I've been an active advocate for a Bill of Rights, or a Charter of Rights in Australia for quite a long time. But what I think has happened in Australia, which I think is interesting, is that in the absence of allowing the judges to do that sort of work, and that's always the big opposition whenever debate about a Bill of Rights comes up. The reason, and there's been 3 different occasions in Australia's 120 year history now, where there's been the possibility that a Bill of Rights could be enacted, and it's failed each time. And that is that there's this fear about the judges getting involved in these sorts of things and what might happen. I don't share that fear, but a lot of people do. But the point is that therefore, in the absence of judges doing this sort of work, the legislature has actually stepped in some cases to fill that void. And one of the big roles that the legislature can play is not just through the enactment of legislation, but also in establishing royal commissions, okay, and inquiries into various issues. And I think that that's what gives me just a slight degree of, a minimal degree of hope, I think, actually, in the Australian setting, is that there are two royal commissions that have occurred. One occurred in 2017 or finished in 2017, and one is underway right now. And I mentioned them both in my presentation. One is the 2017 Royal Commission into Institutional Responses to Child Sexual Abuse, one of the first inquiries of its kind in the world to do that. And the one that's currently underway is the Disability Royal Commission. And those two, and that's still happening. The findings in the report has not been issued yet by that Royal Commission. But both of those are catalyzing, I think, a commitment to providing better responses in a range of different ways across Australian life in relation to the education of children and the education of children with disabilities. And so I think that is where I feel that, like I say, I've got a slight degree of hope, I suppose, that there's a lot of commitment to that right now in Australia, to both of those principles, the education of children and education of children with disabilities. And so I think that could lead to some better outcomes. But as every speaker, and as I said earlier myself, the issue is always money. So, you know, and I mean, and the other thing is that once these things happen, you know, there's sort of like there's a moment to act, and then if that moment sort of goes, you may not get it back again. So that's my fear on the other side, is that, you know, there's a lot of commitment to this right now, but action needs to be taken fairly soon. Otherwise, that moment will have passed.
Okay, thanks. We did get a question in from an attendee, which is a real good one. I'd like to raise it if there's time. I may raise one last question for our panelists. But here's the question. An idea of the right to education was mentioned in the US. Parents have the right to related to education, but currently it's not the child's right. Can any of the presenters speak on this internationally? Nina, I might throw that to you first, only because of your chair on the right to education, but certainly Paul and Bill, I hope will join in, and Alan, if you want to join in on that as well. Nina, do you want to pick up on that?
Sorry, Charlie, I didn't understand everything.
Sure. Here's the question. An idea of the right to education was mentioned. In the US, parents have a right related to education, but currently it's not the child's right. Can any of the presenters speak on this internationally?
Charlie, sorry, it's not, the sound is not good. Sorry.
Oh,
about
I'm
this.
sorry. Okay,
Would you like to send me the question through the chat?
if I can figure out how to do that, fine. Perhaps Jordan, could you do that? Or Leanne, if you're listening, I'm not sure how to do that. Did Paul or Bill, did you hear the question while we try to get that to Nina?
So the question is whether or not it's the parent's right or the child's right for education. Is that the question?
I think so. If the
Okay.
question,
Yeah.
Okay, got it.
okay.
This is the children's right, not the parents' right. It's a fundamental individual right, and not, but even a social right. So the society has the right to have the children educated as well. But I'm sure the right is the children's.
Are we addressing a question, person in the audience? Jessica just sent it in the chat feature. Thank you, Jessica. Can you see it in there, Nina? Does anybody else want to address that, or have we addressed it?
Yes.
I'm giving 30 seconds to look at that.
Well, I can speak to that in the Australian setting, and that is that I don't think there's a right either way in the Australian setting. So I don't think it's either the parents or the child's right. What I can say is that in Australia, the national principles for child safe organizations that I was talking about in 2018 is an attempt to implement Article 3 of the Convention on the Rights of the Child. So to the extent that I suppose that there is any right that relates to education in Australia, it may be the child's, but I don't really think that that's actually a position that's well established in Australian law.
Okay, Bill? You want to speak about Canada, Bill?
Yeah, so my gut feeling is in Canada, although I don't know the answer to that 100%, my gut feeling is that children do have a right to an education in Canada. And I can think of several cases where courts have intervened And they said that the child has to attend school unless they're going to be homeschooled. But otherwise, I think by law, these students up until a certain age have to attend school whether they want to or not.
Alan, I don't know if you want to jump in on this, but there's a case in the United States, Winkleman v. Parma, a case from Ohio about 10 years ago. The Supreme Court interpreted the IDA as saying kids have the rights, but parents have a separate right they can enforce through litigation as well under the IDEA. Alan, do you want to amplify on that at all?
Yeah, basically, I do feel that the children in the US have the right to education, but it's pretty much the state right, not a federal constitutional right, as we've mentioned earlier. Winkleman, in essence, basically did say that the parents had the right to, sue to get what they wanted for their children, which I feel is pretty much a given with the IDEA. Throughout it has a lot that talks about parental rights. They have the right to be part of the IEP process. They have a right to get their children's records and so on. So to me, it's very much a joint right between parents and children.
Good. Anybody, any final comments from anybody? Final thoughts?
Well, Charlie, I'd like to add that this very question, whose rights is the education, the right to education, it was debated by the Supreme Court in the case of, I forgot the name in English, education at home, homeschooling. It was debated if the children, if a child has the right to go to school, or if the parents could decide to offer homeschooling to children. And it was decided that even at homeschooling, the children have to be assessed by public schools or even private schools, and not maintain apart from socializing, etc. So the decision was based in the idea that education rights is an individual right, and so any children could be deprived of this right.
Okay, thanks. 1925, Pierce versus Society of Sisters in the US said the child is not the mere creature of the state, that parents have the right to direct the child's education. God willing, in 3 years, in 2025, that'll be the focal point of a day like this. Before we break up, I'd like to take the opportunity to thank some people with apologies should I leave anybody out. Behind the scenes, let me thank Leanne Ross, Jordan Burgess, and Jessica Paprocki for all their work answering emails, doing the technology and everything else that helped make the day successful. I'd also like to thank, of course, Associate Dean Lori Shaw and Head Dean Andrew Strauss for their support for this day moving forward. It goes without saying, we'd like to thank all of our panelists, those who are no longer with us. We hope that those of you watching, and we've had over 50 all day long, which I'm told is a pretty good number for an online session like this, particularly running as long as it did. We are hoping to gather next year. So I'd like to throw this out to you. I've not even spoken with Dean Shaw about it. Next year is the 50th anniversary of a case in the United States, San Antonio versus Rodriguez, which said that education is a right belonging to the states. It really focuses on school finance. That may be a bit narrow, but that's one topic we'll throw around. Another topic we might consider for next year deals with the status of religious freedom. As Alan alluded, just this past year, the Supreme Court ruled that a football coach could pray on the field in Bremerton versus Kennedy. The court upheld the right of kids in Maine to attend faith-based schools under a state law in Carson v. Macon. For those in the audience, if you could think of a topic that really turns you on, as it were, or a topic you think that would be great appeal, we're going to start with those two and put together a committee over the next couple of weeks and try to see where we move forward. But we are certainly planning to do this again next year. We hope our panelists will return next year, and we hope those of you in the audience will return next year. I would like to thank everybody again for all of their help. I've enjoyed today listening to our speakers and engaging with everybody. I hope you did as well. We hope to see you again at a future session like this. But if there are no further questions, my clock says 3:59, so we're actually pretty good on time. So with that, I'd like to thank everybody for coming. Wish you a good weekend. Paul, I wish you a good night at 4:30, 5:30 in the morning. And we'll see you all soon. Thank you, everybody. Stay well.
Thanks.
Bye-bye now.
Thanks, Charlie.